So I'm afraid that like to mention the same 34 Malods which I had mentioned yesterday, Malods. It
34
was
come in due course.
Malods, I understand Malods. Actually, it was no excuse, but just traveling from Delhi for the matter, Malods. It was supposed to be listed at 3 p.m., but I've been told there's a
No,
division
it's at
bench.
3 p.m. We have never fixed a time.
Malods, it's at the 3 p.m. list as item 127, Malods, but there's a division bench matter. So
It won't
Malods,
come today.
it won't reach today.
It won't reach today.
Malods, if a date could be fixed, Malods, I'll accordingly
We'll
plan.
see it. We have put it in the list. We'll see.
Malud, then can I, Malud, because Malud, I'll have to then I understand, Malud. I don't want to bother the court too much, Malud, but it matter. There's urgency in the matter. Malud. This is Steel Authority versus McNally
All
matter.
the matter, there's some urgency.
I understand, Malud.
We have put it in the list. We'll see whenever we can take it.
Can a time date fixed matter be given, Malud?
No date can be fixed. We'll take it up.
Malud,
Whenever the list will permit, we'll take it up.
Today, Malud, can it will
Not today.
Not today, Malud.
My lord, I may be permitted to mention for withdraw. My lord, I already mentioned in last occasion, but not listed yet.
कॉल क्यों नहीं लगा?
Not today. 127. If they
Yes. Call out the
statement item number 1.
This is the matter which Lordship remembers that award. I was at least saying interest apart which is payable, at least what they had agreed on 4th of February, that much, 5th of February. In the 5th February order, what
There's been a change in the file. Yesterday only I received the file. I need some time. I see there is an order that the here's an exception.
Yes.
The order dated 5th of February. My lord, I stay for some time.
to pay or to take, to pay, I
for
hope.
2 weeks, for 2 weeks, man. I haven't checked my
To pay to
Learned Council for the Respondent State, Calcutta Metropolitan Development Authority states that he has been recently engaged in the present matter. He prays for an adjournment to get himself acquainted with the brief and the orders passed by this court. Does it matter? Are you 2 weeks? Nothing will happen. You keep it after 3 weeks or 4 weeks. Keep it after 4 weeks.
the affidavit of service. The affidavit of service.
Affidavit of service taken on. Affidavit of service taken.
Not 2.
And for the judgment data, Lordship. Lordship, in this
Lordship,
matter-
Lordship, I'm
Lordship, I am for the judgment data applicant. Lordship, I have filed an application.
Complete. Into
Lordship, I have challenged the jurisdiction that this court original site, High Court original site doesn't have the jurisdiction since neither of my property within the limit of this court, Lordship. Lordship, kindly take up my application, Lordship.
My lord, this application is appearing for the first time. The other side, the award holder, my lord, has not yet filed any affidavit in objection to this. So, my lord, if they don't want to file that objection, then it can go for a hearing. My lord, there are three-folded objections we have taken. Number one, point maintainability on the ground of territorial jurisdiction.
Mr. Chakrabarti, wait, your voice is not clear. Yes.
We have challenged
Yes.
three Lordship. One is the territorial jurisdiction. Another, this order they have annexed it is not impound because there is no stamp duty. And thirdly, we have challenged it under section 47 because the award which has been passed, it has been passed without considering this goes to the root of that. This is a total nullity. It has not considered many aspects. It's a MSME award, Lordship.
Whatever it is, 47, you have to, unless and until it's a nullity on the face of it, we're not going to interfere in 47.
Lordship, it is, Lordship, just imagine, Lordship. if
Madam,
the
on merit,
arbitration,
there is no 47.
Lordship, let me place one by one then, Lordship.
Yes.
Lordship, kindly comment the first I have changed challenge
GA1.
this award. Yes, Lordship. GA1, Lordship. Lordship, I have annexed my affidavit of asset, Lordship, which I have already filed in. Lordship, kindly come to my affidavit of asset, Lordship, once. That is in the page number 26, Lordship.
What is your GA?
GA1, Lordship, IAGA number 1 of 2026, Lordship.
Yes.
And it is regarding, I have challenged it in the first aspect. Lordship, there is no territorial jurisdiction of this honorable court. Lordship, why I am saying so, Lordship? Lordship, kindly come at page number 26, which is my affidavit of asset in the GA. Lordship, got it in the
Yes.
হ্যাঁ দেবো বলছি আপনি বলে দিন
नहीं नहीं दे रहा पैसा नहीं बोला
Yes,
Lordship, if Lordship comes with my to
speak
my
in the mic.
affidavit
I
of
can't
asset,
hear you.
Lordship, if Lordship comes to page number 26, it starts my affidavit of asset, Lordship. Lordship, I have declared in my all affidavits lying beyond the jurisdiction, territorial jurisdiction of this honorable court, Lordship. Lordship, it is starts from page number 29, Lordship. My register office and whatever property I have and movable and immovable, not within the territorial jurisdiction of this honorable court, Lordship. Lordship, kindly comment, kindly take only section 39 of the Civil Code of Civil Procedure. Lordship, may I, Lordship? Court by which decree may be executed. By a decree may be executed 38 and then 39. Either by the court which passed it or by the court to which it is sent for execution. Lordship, it is the MSME award, Lordship. Transfer of decree. The court which passed a decree may, on the application of the decree holder, send it for execution to another court or competent jurisdiction. If for the
Just a
person
minute, madam.
38 টা পড়েছি 39 টা দেখাচ্ছে
सेक्शन तो
if the person against whom Lordship, I'm
Your ground is that basically nothing is located in the
within
territorial
the territorial
jurisdiction. Yes.
jurisdiction. Lordship, nothing is located. Neither of my property is located within the
File your reply.
lordship I want to say that section 47 of CPC applies to execution of degree but
Oh, madam.
section
Nobody is saying that it doesn't apply. She is saying that you don't have any property according to the affidavit of asset
But
which you have filed.
in the affidavit of in their own affidavit para 11 13 15 they are admitting their assets of 430 plus 430 crore and fixed deposit is 50.57 crore and bank account 15 crore and receivable of 53 crore.
Do you understand what I'm saying?
They are admitting
Do you understand what this court is saying, madam?
yes they are admitting they are saying there is no jurisdiction of their assets
Why?
because
Why?
they are registered office but at Baguyati Kolkata so how we
Not within the jurisdiction of this court. This is not the court for execution of the order. They are not saying they don't have the money, but they are saying this is not the court.
appropriate order so
File this application where the property is situated.
this property they are admitting their property is situated at Titagar at their assets are
That's what I'm, madam. So what does it mean? If the property is situated in Titagarh,
which
that
is
this court doesn't have the jurisdiction. The 2-1E court will be the court over there. Then how have you filed it here? The execution petition. That's what they're saying. Who's your senior?
is my senior
लॉर्डशिप में
Appropriate
पास
time.
appropriate orders
Appropriate orders will be you withdraw this and file it in the appropriate court.
So be it, your lordship.
Learned counsel for the petitioner seeks to withdraw the present execution petition with liberty to file appropriate proceeding in accordance with law. The present petition is dismissed as withdrawn with the liberty as prayed for. All connected applications are withdrawn. All your applications are gone, along with all.
Okay, I'll file it before the court where they will file their execution lordship. Deeply obliged.
My lord, in this matter, Mr. Amitabh Ghosh is not appearing in this matter.
Yes.
But he has till now he has not reached in the court. My repeat lordship.
So shall we wait for him?
My lord, make it not today.
Is this 11 o'clock is not here? Not today.
My lord, may I submit one last 3 occasions it was adjourned, my lord. It's a execution application is, my lord, barred by law of limitation,
No.
my lord. After it has been filed after 15 years, my lord. So 136 of Limitation Act will apply, my lord.
My lord, I
He is not here. Next week, kar do. Not today.
wait for it.
My lord, the advocate on record in this matter has not well, my lord. She has not recovered yet, my lord. My lord, I am paying for not this week, my lord.
Not this.
Hateful, my lord.
No, 5.
Petition.
আবু তোমার জুনিয়র আমাকে সব ফাইল এখানে পাঠিয়েছে
This is my application for execution of an award.
Yes, Mr.
Well, there has been
President.
no stay in this matter, my lord. Earlier, my lord, section 36 was there in the list. I suppose it was supposed to appear today, but it does not. But my execution is there, my lord. They have not taken the endeavor to ask for a stay of this award, my lord. On the last occasion, I handed over a copy of the calculations to my learned friend, my lord.
Why that is not listed? APCOM.
It's in the monthly list. Sorry, my lord.
There was an order to for the AP.
অর্ডারে ভুল রেকর্ড
Yes, it's there. Both are listed.
34
The 34 in my
Actually,
respect.
it's the 34
I
which has come. And
Not the 36.
number 6, my lord. The next matter is the 34.
No, but that is the number you gave me. APCOM 946.
Just to confirm, you'd like to call.
My
That's what you have given on the last date. That's
When I'm
why I did.
It's there in the monthly list, my lord. It's in the monthly list, so. My lord, I can proceed with the execution.
So if they are depositing the money
I
there,
don't know whether they're going to deposit. Please, the stage is yours.
In my respectful submission, Miller, this award has been challenged by both the parties, of course, on different grounds. The basic contention of the award was this is with regard to a dispute where helicopters were to be supplied to the army for basically maintaining a surveillance in the northeast region. There were certain do's and don'ts which were not performed, and then after that, Lordship, now, Lordship, the matter went for arbitration. The learned arbitrator came to this finding that you pay 80% of the amount of those copters. Subsequently, thereto, they will give you return that quadcopters to them, and those will be repaired, and then it will undergo an ATC, and
that's
subsequently.
on the merit of the matter today.
Just a cursory view, what actually the story is, dispute is all about. Now, Lordship, they challenge that award, saying that the balance 20% is to be paid to them. Section 34 is pending before your Lordship. We challenge that award on many grounds. Some of them, one preliminary ground is fraud. Second preliminary ground, Lordship, is that those quadcopters have lost their lives. They cannot be repaired. So be that as it may. Now we took out a 36 application before your Lordships within time, which is along with section 34 application. Since both the challenges were pending before your Lordships, this Honorable Court, my lord, that 36 application could not be pressed. Be that as it may. Now, my lord, what I'm humbly submitting is, as far as their calculation is concerned, 4 crores and odd is that 80% pedestal which we are supposed to pay them as per the award, and then they will perform their part of the award, which they cannot because of the it has become irretrievable damage has been done. So, Lordship, and then they have calculated interest thereupon, which makes that quantum to about 8 crores and odd. Now, Lordship, what we are submitting when the matter is placed before your Lordships, because my Lords are not having the brief now of 36. But what I
have 34, only 36 is not here.
My Lord, that 36 was being heard, was to be heard before.
You gave me a wrong AP com and you
My
didn't
lord,
correct it.
my Lord, my Lord.
The last order.
Yes, my lord, I
My
see.
lord,
the
for that
last one.
unqualified apology from my side, my Lord. That is
Last
my being an officer. My being an officer, my Lord, it was my duty.
It's both of you. You know, the whole idea of keeping this matter today along with that was that you will deposit the money in 36.
My Lord, my Lord.
That's what transpired on the last.
Yes,
Last
If I remember
yes,
correctly,
it was my execution which came up, and well,
yes,
they said
yes.
my mistake.
that
Well,
was
I
the
could not
whole
find the
idea.
number, my lord. Obviously, my lord.
Keeping the AP com together.
So that they can be a stay, my lord. That was the idea, my lord.
Lordship is perfectly what has fallen from my Lord. It is my folly, my Lord. I being the senior most among all, even my Lord, I should have
take the bullet.
My Lord. That goes how we goes in our institution. Because taking responsibility even for my Lord, I should not have wasted my Lord's time. But my Lord, just giving a recapitulation to my Lord, what I humbly submit, my Lord, that quantum of interest which they are impressing upon to be paid, yes. That particular thing where we are joining up. And secondly, Lordship, as per instructions, my Lord, fraud has been pleaded by us because later on during cross-examination, it came that we said that it should be indigenous, but those technology and know-how were taken from China. And that's a sheer compromise on the safety and security of Union of India, because it was to be used for surveillance of the border zone on Northeast, where we have issues with the Union of China. So be that as it may, those are two. So on that ground, my lord, we were pressing that, my lord, 36 is there, my lord. There is a specific statute saying that we have to deposit as if it is a money degree, my lord. So therefore, I'm not pressing. We are creatures of instruction, my lord. They have to submit before my lord. But my lord, I will not be, being my lord's officer, I will not be. So my lord, as far as money degree is concerned, my lord, the quantum of award is 4 crores and odd. My lord,
may I assist your lordship with the calculation if your lordship wants it? I've given him, my lord.
my lord, only point is, my lord, whatever he's saying, my lord, I'm not disputing it. My lord, he's saying, my lord, they have said, my lord, that the contract value was 6 crores and odd. Award says 80% to be paid of the contract value. That comes to 4 crores, 82 lakhs 40,000. Now, lordship, they are calculating interest at the rate of 9%. Of course, that is a part of the award. From 3rd of March 2018, and lordship, and they are going on calculating it till lordship August 2026, when my 36 application was pending. Well, I'm not saying that they cannot claim, but Millard, they cannot be a straitjacket formula, Millard. As far as this case is concerned, where the factual matrix goes to show that both have challenged the award. So, Millard, in those circumstances, lordship, I think there is a bright chance that the award may be modified. Maybe, I'm just, hoping against hope, according to my learned friend. So, under those circumstances, if we are put to that particular provision of CPC or even section 36, we are ready and willing to, give a Reserve Bank guarantee to the tune of 4 crores 82 lakh 40,000, lordship, and subject to whatever falls from my lord.
See, I think the law is very clear.
My lord,
I can't modify, neither I can do anything.
I never said, my lord. I said, no, my lord.
First of all, in execution, I'm blind. To the extent that whatever is the award, I have to get it executed. Whichever way the award has been given, rightly, wrongly, that's your 34.
My lord.
You go in 34,
I bow.
have a ground, you raise it.
I bow.
I can't look into it under the execution.
I bow. I bow.
And neither can I modify it.
My lord. But I am on 36.
36 also, whatever the law says, you have to
Yes,
deposit.
my lord. So law says, my lord, as far as that is what I am going to press before your lordship, as far as 36 is concerned. I
And
am,
even 36, it's the award.
yes, my lord. Award.
Whatever is there in the award,
Yes, my lord.
you have to.
Award, my lord. But then where I'm joining issues, lordship will kindly appreciate that 6.
All those issues will be taken care of in your
No,
30.
my lord. Why only to that aspect? If my lord kindly
If the
allows me.
interest has been awarded, in
Yes.
the award,
Yes.
from the time to the realization, whatever amount is, you have to deposit.
My lord, in my respectful submission, my lord, I would try to most humbly submit before my lord.
Can I change the interest?
No, my lord. My lord may not change the interest.
Can I stop the clock?
My lord can, but my lord may not, subject to what my lord. My lord,
You
that
show
is-
me the law that I can.
my lord, I will try, my lord.
Show me, Mr.
I will,
Trivedi.
I will try, my lord. My lord, I will because
No, show me the law, I will do it.
because my
And
lord,
at
what
least I know this much. And when I was in a position, my lord, I cried horse on this one and I lost at every court. In every court I lost.
See,
my
these
lord, every day is
amendments.
a new experience.
See,
My
you
lord, we
know,
are born to
Mr.
my lord,
Trivedi, with the
lotships.
new amendment, 36 has been added.
Lordship.
So, and you know the scope of 36 also. If you can enlarge or modify, you show me the law. We will be inclined to hear you on.
My lord, the judgment which is being relied upon by my friend, which he was intending to place before your lordship. The word is, my lord, the award amount, my lord, I would intend to amplify on that. That it is 36 is there, my lord, but interest is concerned, lordship. If I file my application under section 36 and it is pending before my lords, and my lord, for some reason or the other, my lord, and when in the light of the circumstances where 34 for both the parties is pending before your lordship, so, my lord, that is a particular factual matrix which I would intend to rely upon.
I'm ready to hear you. Show me the law. We can do it.
Well, may I come back tomorrow?
Come back Monday.
My lord, I am coming back on that.
Let all these matters. 36 लगाओ.
So, my lord, if I, my lord, if I have rightly understood what has fallen from my lord, I will just be very brief on the point that lordship, the interest portion which has been claimed by them by execution.
I'm only giving you the opportunity. If I can pass an order, I can pass an order in execution. I can attach everything, whatever the calculation are till date according to the award.
Yes.
Just to shorten it, just to make things better. You know, we are hearing the 36 also to the extent that whatever it is, they'll be protected. The whole idea of execution is that they need their protection as far as the money is concerned.
I'm grateful, my lord.
So
My lord has given me an amnesty till Monday to come with these points. If I can satisfy your lordship,
we'll see that.
I may try my
No.
because my lord, it's
It's always a pleasure, Mr. Trivedi, to hear you. So we'll be enlightened by the.
It's not. It is my lord, our duty as an officer of my lord. Because the other day while I was arguing,
See,
I was saying,
law is evolving.
Lordship.
So we'll see.
My lord, because the other day, my lord, I was arguing before the honorable coordinate bench of my lord. I said that statute, we say statute in its wisdom is promulgated. But the teething problems which execution process faces and the agony of the people, that is evolved, the interpretation is evolved through judicial debates. I will not say debates, lordship, by we as officers assessing your lordships to come to a conclusion and understand the teething problems and the grassroots levels. So, my lord, all these judgments which are here before my lords and which we rely upon are an outcome of, my lords, whatever we pray before my lords. And then, my lords, after. My lord will he has been a junior in my college, my lord, and
But I could see waters in his eyes, my lord. That's why I told him that.
No, that is the art of my, my lord, oratory, my lord. I do not know because that is the craft. I become emotional with my arguments.
Absolutely.
So, my lord, that seems that how, I
Passionate you are.
so passionate. I am passionate.
Absolutely.
But I'm keeping a record of this submission, my lord, because I will find him on the other side while he's defending for the state, my lord. I'll make the same submission.
My lord, for an advocate, we step into the shoes of our client, subject to not being overzealous about it and understanding the nitty-gritties of law. Because client can come and tell me anything, but I am not his spokesperson. I am an advocate first. So that is why, my lord, I am taking one more day's amnesty. If I may.
No problem at all.
My lord, I'm indebted for that.
Did I oppose?
36
Calcutta knows to go.
36
other side की confirm करो.
But only one thing, my lord, if it could retain its position, it's just a request, my lord.
We're retaining for,
Keep it on Monday.
Very grateful to your lordship. Very grateful.
Should I record the APCOM so and so should be listed? Yeah. Monday.
number ठीक है ना? फिर गड़बड़ नहीं हो.
So will they clear your bills if I record one line?
My lord,
All right. Take
my lord, may record, my lord, because my bill, my lord, I don't.
Third learned senior counsel, learned ASG,
No, ठीक.
Dheeraj Trivedi. Let APCOM so and so be listed along with this on Monday.
Grateful.
সাতচল্লিশ ঠিক আছে পাঁচই অর্ডার হলো অর্ডারটা পাঁচই অর্ডার করুন থার্টি ফোর 36 একশো and now 7
I appear for the petition amendment. This is my execution application seeking execution of an arbitral award dated 26 December 2025, my lord. Page 70 of my application is the order in question, my lord. Page 70, 2.37 crores principal and over that interest of 6%, cost of 13 lakh and over that 6% interest.
The takedown. The award holder has preferred the present execution petition seeking implementation of the award dated 26/12/2025 passed by the arbitral tribunal. Full stop. The award debtor is directed to file his affidavit of assets within 4 weeks. Affidavit of service to be filed on the next day, on the next returnable date. List after list on after 4 weeks.
4 weeks.
Within 2 years.
Yes, with least after 4.
Eight.
Item number 8, your lordship, this is my execution
The award
application.
data, not accepting 2 weeks time to file the affidavit of asset. I believe 75% of the award has already been.
Not affidavit of assets. Today, your lordship, the entire 75% of amount, your lordship, has been deposited with the registrar original side. Now they chose, your lordship, that they will not deposit, your lordship, the 100% for getting a stay order. Arbitral award is of 2023 and your lordship, the first order passed by the honorable court regarding the deposit of 75%
Order should
was passed sometime, your lordship, in the year 2024, page 60.
Page?
Page 60, 60. Page 60, your lordship, Justice Bhattacharya, your lordship, directed for the deposit of 75% amount. Your lordship, kindly take page number 62. Now, after this order, they chose, your lordship, to only deposit 25% of the principal amount. We came before your lordship and your lordship directed them to deposit 75% of the entire amount. That order, your lordship, is at page 68.
I had been given instruction that perhaps the 75% has been deposited. Kindly
Yes, sir.
passes it over. Not the,
That has been deposited. That has been deposited. 75% has been deposited to maintain an API, section 34 under the MSME, your lordship, award.
Yes, 90.
Now there is no stay because they chose not to deposit, your lordship, the 100%. They've never chosen, your lordship, to get a stay order from 2023. Now, your lordship, kindly take my tabular statement, what I am, because the last page, if your lordship, another see, kindly come to page 72. The amount is lying there. So I am entitled to withdraw that amount. Page 72, your lordship, kindly take. This is the fund certificate issued by your lordship, the original side High Court. Initially, your lordship, 25,37,376.75 has been deposited. Subsequently, page 73, 46,93,434.05 has been deposited. So total amount is coming to 72,30,810. That is your lordship lying with the registrar original side. Today, as on date, may I just show your lordship what is the total amount which is due and pending. Lordship, kindly take page 14, paragraph 26. As on today, your lordship, this amount comes to 1 crore 4. So today I am praying your lordship that amount may be disbursed in my favor. I am an MSME, your lordship, otherwise it's very difficult to your lordship, sir.
You are just seeking the execution of the award, right?
Yes, I'm seeking execution of the entire arbitral award.
Yes.
Money is lying with the registrar only, sir. So today I am seeking your lordship prayer B of the tabular statement. Your lordship,
Be given.
yes, Lord.
Can't be given. 34 is pending.
Yes, but there is no stay.
That's right.
If there is no stay, your lordship, I can
One application, whatever the amount is pending, can't be released like this.
prayer B and order be passed direct in the registrar original side to disburse a sum of rupees 72,30,810.
No.
The mere pendency of the section 34 application will not debar me, your lordship, from moving an execution application.
That's all right. Move an application, we'll pass a appropriate order. You have to furnish a bank guarantee for that amount.
I understand, your lordship, that
Just can't give you the
if there is a stay, I make a counter bank guarantee and I am entitled to withdraw the money. There is no stay today.
That's all right.
If there is no stay, your lordship, there is no embargo.
I understand, sir. There's no embargo, but we all know what the procedure is. Yes. What are you planning to do? Deposit the rest of the 25%?
Kindly gives me 1 week time to come back with the instruction, my lord. Today only
Deposit your 25% so that you get a stay.
I'll instruct them. Today only I've been.
Otherwise, legally, he is absolutely right. He can withdraw the money.
Kindly gives me 1 week.
But then you are 34 after that. Next week. Come back with the instruction, deposit the rest of the money.
And on 9.
Technically, you are absolutely right. But you know the fate of 34.
Yes, your lordship, I understand also, but if they deposit it, your lordship, I'm
You can take
counter bank guarantee. If they don't, your lordship, then I'll press.
May it please your lordship, my lord. I picked up here for the applicant, my lord. This is the execution application coming up for the first time, my lord. The award dated is 28 July 2015, my lord. The judgment data are within the jurisdiction of this honorable court. As it is after 11 years, I was humbly praying for issuance of notice under Order 21 Rule 20.
What dated?
28 July 2015, my lord.
Why you are coming now?
My lord, there was talk of settlement between the parties that they will pay off the dues as per the award, but they are due to some, my lord, administrative decision, and there was change in management also. We were delayed, my lord. But we are within the limitation period, my lord.
Who appointed the arbitrator?
My lord,
Unilateral appointment.
unilateral appointment, my lord.
Then this will go.
Now, this is back in 2015, my lord. If my lord goes by the TRF judgments and all, my lord, it is back in 2015. The award was passed in 2015.
Which date? Of
28th July 2015, my lord. My lord, find the date at page number page number 14 of the application, my lord, dated at Chennai on July 20th, 2015. I was humbly beseeching that is beyond 2 years, my lord. Let a notice be issued under Order 21, Rule 22.
What is the cutoff for that? 16?
12 years, my lord. For execution, my lord, 12 years.
No, not execution. That unilateral appointment,
16, my lord, 16.
16.
Subject to correction, 16, my lord. It is
Next
prior
week,
to
I'll
that.
let me check the law. Keep it
Ma-
next week.
Next week, my lord. Grateful, lordship. My lord, I shall also come back with it, my lord. Grateful.
Not happy to appear, Lord, in a non-unilateral award, Lord. Lord, arbitrator appointed by the Honorable Court, Justice Ashok Ganguly, Lord, was the arbitrator. Lord, the award, Lord, awards a sum of rupees 5 crores, 4 lakhs, Lord. This is not less than 2-year-old. Lord, there was a section 34, but no stay, Lord, moved. In fact, Lord, we had filed a section 9 when your Lordship was pleased to observe that since there is no stay, why don't you withdraw? So, Lord, we withdrew the section 9, Lord, we will file this execution. Lord, I am not praying, Lord, for order, Lord, in terms of prayers, Lord, B, D, G, and Lord, Lord, A, B, D, and G, Lord. I'm sorry, Lord. A, B, D, and G. Lord, A and B, Lord, pertain, Lord, to Lord, attachment of bank accounts. And Lord, G is not restraining them from dealing with their immovable properties, Lord, and D is not filing of affidavit of assets, Lord.
Where's the bank account detail? Page?
So, Lord, para 26, Lord. Lord, page 11.
Page 11.
Lord, prayer B mentions paragraph 26, Lord. Your Lordship, Lord, may limit the injunction to 5 crores, Lord, whatever is the awarded amount, 5 crores, 63 lakhs.
Take down. The award holder has preferred the present execution petition seeking implementation of the award dated 4th December 2025. The present execution petition is well within time. Let there be a prayer
A, B, D, and G, Lord.
prayer A, B,
Lord, D is affidavit of assets, and Lord, G is the immovable properties.
G is what?
Lord, D is affidavit of assets, Lord.
G, we can't give it. You have details of the property?
Lord, we do not have details of the
So
property.
not now. Prayer A and B.
D also not, Lordship, consider. Let them file the affidavit of assets so that, Lord, we know.
That will pass or not.
Great.
Prayer A, B. As prayed for in the tabular statement is okay. Full stop. Affidavit of assets shall be filed by the judgment debtor within a period of 3 weeks. Affidavit of service shall be filed on the next returnable date. List on. Give after 4 weeks. उसमें से लिख देना A and B to the extent of the awarded amount.
May I give the figure? It's 5 crores, 63 lakhs, 71,000.
5 crores. Let there be a injunction on the A being granted to the extent of rupees 5 crores.
63 lakhs, 71,000.
63 lakhs 71,000.
Copy written. Great.
Yes, next.
11.
My lord, in this matter,
For the award holder.
award holder as per the execution, my lord, was hearing a section 47 application, my lord.
Yes.
Senior Mr. Shah was addressing your lordship.
Yes.
We had placed, my lord, electro steel on the aspect of maintainability. Now, my lord, to delve into the merits and address your lordship on whether this in fact constitutes a nullity, my lord. But we were hoping to come back tomorrow if your lordship permits, my lord,
Junior Mr. Sahu can do
a little bit more legal research is done. I'll be very candid, my lord. I've dug up some judgments this morning, my lord. My senior has not had the chance to consider it. I was supposed to share the judgments with them, my learned senior friend also, but I have not been able to do that. If your lordship will allow us to come back tomorrow only, my lord, I can address your lordship.
And leave it to what will I say?
If your lordship
They have
insists, my
given
lord,
their affidavit of assets. It's a claim for 400 crores, 22 lakhs, the principal claim.
my lord, but we are arguing
And
now.
their counterclaim for 600 crores was dismissed. But they have given their assets. They have the assets with HCL, my lord.
Yes.
Some sort of and they are refusing to move their section 36 and 34 before the Jabalpur
It's
court.
pending, my lord. We are arguing the same point of nullity here also, my lord.
Okay.
If your lordship says,
So,
I'm prepared to
lordship
start
keeps
and
it
go
for
on for
next.
some time.
I don't want to oppose my learned friend, my lord, but and your lordship keeps it, but some sort of security they can offer us.
Yes.
It's a.
Yes.
Oh, next week.
Lord, several judgments. I don't want to burden your lordship. I was not there yesterday. I just want to select the judgments that I want to rely on. But just one day's time.
Next Thursday, not today.
I just want one day's accommodations.
Readings and all are complete.
Yes, everything.
So next Thursday.
Grateful.
This is Hindustan Copper, so you need not worry. Where will they go?
I know, but then it's Jabalpur. We both have to go, but it takes 3 days to go. But he's not willing to go.
It takes 3 days to go.
I hope
2 days to go, 2 days to come back, 1 day to do the matter.
and 2 days for bench.
He says 2 days for bench.
This is a wildlife sanctuary.
12.
Okay, I need to find my affidavit. I already saw my learned friend also.
Lord, this is really the question of Lord, the implementation of the award, which was challenged, lost. Now the question of payment, which they are not making. That's the whole point. My Lord, can you see the order which was passed by this Honorable Court on 9th of the order to the 9th December 2023. 9th of December 2023, before Honorable Justice Moushumi Bhattacharya, they say kindly give us some time to comply with it. Till then, Millard, no compliance. Some payments here and there, but not complying with the.
Yes.
Yes, ma'am. My lord, the principal and interest, my lord. In principal total has been paid up.
Whatever it is,
My
they
lord.
had given.
My lord, my lord, my lord.
See the order last.
Yes, my lord.
Where's the calculation sheet?
Yes, I have annexed. My lord, interest is concerned. According to us, I have annexed here. And out of which I have paid. The balance is, my lord, kindly come to.
Page 31 is our.
My lord, kindly come to last page. That is page 15. Annexed here. Page 15 of my lord. Opposition. Just affidavit, no, just placed before your lordship.
Yes.
My lord, page 15 start. Kindly, my lord, 16.
Yes.
Last block.
Yes.
5 crores 7 lakh 6,200. Principal repaid 4 crore 32 1 lakh 2,000 on 16 February 2023. Then 3 crores. We have paid 1 crores 44. The balance is 3 crores. Please. Total principal has been paid up. Thereafter, we pay the interest. According to us, interest 3 crores 63,080 lakhs 873. Out of which, my lord, we have paid. Kindly come to the order. Kindly come to page 14.
14.
Order by Justice Sarkar.
rupees 2 crore 41 lakhs was paid on 19th May 2025 toward interest component. The dispute is now with regard to the remaining interest component. The award paper submit that no further interest payable interest on interest cannot be demanded, whereas the award holder submitted the principal which was paid appropriate against the interest. Let this payment vacation. Now, out of 3 crores and odd, we have paid 2 crores and odd. Balance I am ready to pay. That is the order.
Yes. That is the order.
That is payment.
Section
Specifically
15 and 16 compound interest. Lord, this
Interest upon interest compound.
it kindly takes up Lord, the MSME Act. Lord, this has been agitated by them times without number, and the court has rejected their submissions and said, no, you have to follow the interpretation of the statute. Pilot, kindly come to section 2B, which is the appointed day. That's very important. Appointed day means the day following immediately after the expiry of the period of 15 days from the day of acceptance or the day of deemed acceptance of any goods or any services by a buyer from a supplier. Therefore, this is the appointed day from which interest would be calculated. Now, how interest would be calculated? Kindly come to the section 16. 15 and 16. They want to not really go out of the rigors of the statute. Kindly come to page section 15. Right? Where any supplier supplies, well, got it?
Yes.
Where any supplier supplies any goods or renders any service to any buyer, the buyer shall make payment. Therefore, on or before the date agreed upon between him and the supplier in writing, or where there is no agreement in this behalf before the appointed day. Provided that no case the period agreed upon between the supplier and the buyer in writing shall exceed 45 days from the day of acceptance or deemed acceptance. Then it's important. The date from which and rate at which interest is payable. Where any buyer fails to make any payment of the amount of the supplier as required under section 15(3), there was a failure. The buyer shall, notwithstanding anything contained in any agreement between the buyer and the supplier, or in any law for the time being in force, be liable to pay compound interest with monthly rests to the supplier on that amount from the appointed day, or as the case may be from the date immediately following the date agreed upon, at 3 times of the bank rate notified by the bank. That's what is?
Yes.
Compound interest with monthly rate. Compound interest will continue at the rate 3 times with monthly rate on that amount. This is the thing which they are challenged before the bench under section 34. They failed. The court said, no, you have to make the payment as per the MSME Act. Again, they are raising the same dispute. And we can show from our chart at page 31. And Lord, we have given a detailed chart at page 31. Kindly come to page 31. Kindly takes up, I have given the detailed accounts. My little come to page 31 on 13th of January, the principal awarded was 5 crores and odds. And we have calculated the interest following the MSME Act. Then interest total amount would be 6 crores 95 and odd. This process interest will not increase because of their non-payment. They cannot rake up the issue which was decided by the court finally. Same like award কোথায় আছে আমার speed marking awardটা কোথায় ওতে তো পেজ মার্কিং নেই না ওটা নয় মেন এক্সিকিউশন অ্যাপ্লিকেশন Yes, the award is at page 20 of the application. GA number 3. এইটা এখানে আছে আমার বিপি এত কোনো হাতে আসছিল না কেন
যখন টাকাটা ইনকাম বছর পরে তার একটা পোর্শন দেয় দ্যাট ক্যানট বি কনসিডার্ড
Yes.
Yes. Well, the award amount 5 crore 76 lakhs 1,600 admitted. And my lord, section says 3 time dates the RBI bank rate that have to pay. Well, come to page 15 once again of my affidavit.
Position.
Yes, page 15, my lord. Outstanding amount rupees 5 crore 76 lakhs 1,000. That is the awarded amount.
Yes.
Which is 3 times the RBI bank rate. We have calculated, my lord, calculated. And next page, my lord. Next page. Next page. Yes.
October.
Repaid rupees 4 crore 36 lakhs 012. That is the total principal amount.
How have you calculated the 3 times rate, sir? Show me how have you calculated?
Column number 1, 2, 3, 4. Page 15.
Yes.
Month year, RBI bank rate, circular number at 3 times the RBI bank rate. We have calculated here.
September no. Appointed date. Calculation.
Huh?
My lord.
আমাদের অ্যাকাউন্টেন্ট এবং অ্যাকাউন্টে বসে ক্যালকুলেশন ঠিক করো পুরো বুঝলো
These are all settlement of accounts. It's so difficult for us to do it.
But it's quite reasonable that the court may not go into the details. If your lordship is so kind, will kindly appoint me the chartered accountant from our high court list. Let him calculate.
Both the accountant we sit together subject to proposal for my senior.
You should reconcile the account between yourself and come back to the court. But in all fairness.
Yes, all fairness.
My lord will
It's impossible.
high court. My lord will appoint someone from our high court panel, so that there is no controversy.
Both the accountant will be in presence of both the accountant. In presence of both the
Master and referee, it can be. Okay. Master referee. I thought courted panel থেকে করতে হবে. Referee can be done. আরে referee তার accounts বুঝবে না. But really, it's very difficult for me and the court will have to come to exact conclusions. It's a matter of accounting.
No,
My lord, please to appoint.
your client would know very well. They will also know very
Yes.
well how to reconcile. It is just being created like this where it's not getting reconciled. Neither your client is a saint nor his client is a saint. Both very well know how to play around. Nothing else.
Or my lord, please to will not fix a date. Let their chief accountant will not sit with my accountant and sort it out.
That's much better.
Yes, kindly fix the date so that it's not delayed.
Take down. This is your affidavit or opposition, right?
Yes,
এই
opposition,
account
the execution application opposition.
Reply.
Connectivity is connectivity execution.
Filed by the respondent.
IA,
This is your reply to GACOM 3.
yeah, for 3. IA 3 connected to EC 38.
The reply of the respondent to the GACOM 3 along with the EC is you are filing it today.
Yes, I have
Or this is already you're filing it today, right?
Yes.
It's taken on record. Learned counsel for the award debtor states that the according to you, how much is the due amount?
After 2 crores and 41 lakh paid minus 3 crore and
You were supposed to come up with a figure. Where's the
yes,
figure?
it is mentioned here. 1 crore something.
4 crores.
1 crore 22 lakh.
Where do you get it from? Which page?
Page 16. The
Yes.
interest due shows 3 crore 62 lakh 81,873, out of which I have paid 2.41 crore on 19th May 2025.
That is the order.
That is recorded at page 14.
Where is the figure you are coming from? Have you written the figure here?
Yes.
Where is the figure written here?
You see, the figure is not written, but I am calculating the.
So why didn't you do it? What is the last order? That give me the figure which is due according to you.
এখানে যে হিসাবটা দিয়েছে that is up to February 2023 দেখুন
Why you have not stated so?
ও হিসাব দিয়েছে up to February 2023 এই ডিটেইলস তো পরে আসবে তোমার ক্যালকুলেশন only up to February 2023
আমি 25 দিয়েছি টাকা এই যে
What is the last order, sir?
এই যে
This
19
is
May
the last order to file an affidavit to the,
Giving what?
which is the indicating the amount.
Then where is the figure?
Mistake. It should have been pointed out in my affidavit.
You want the court to do the exercise?
no.
That's why,
I'll sit here with the calculator.
no, so certainly not my duty to.
And why it is not reflecting? Complicating things, nothing else.
Eight seven.
What is the figure?
1 crore 22 lakhs.
1 crore?
1 crore. Yes, I
Give the number 122. What is it? According to you, what is the figure?
2 crore 41 lakhs I have paid.
1 crore 22 lakhs. 1 crore 22 lakhs 873.70.
Is the figure which is due and payable to the award holder. The said figure is disputed by the award holder.
আর এই ক্যালকুলেশন করতে বলতে হয়
Let the accountants of the award holder as well as the
অ্যাকাউন্টিং কিছু
award debtor
on the basis of the
sit together
এটা ওদের অ্যাকাউন্ট বোঝে
to reconcile
এটাই ওদের অ্যাকাউন্টিং
the
ক্যালকুলেশনটা দেখে
figure to be paid
ডিসাইড করবে না
in terms of the award
সে ওরা কি বললো পরে কথা
and a calculation
ওখানে ওরা বলে 2019 থেকে they have been content
sheet shall be filed on the next date by the award holder indicating the amount which is due and payable in terms of the award. Full stop. List after. This will take how much time?
for a good work
I said both of you, your accountant,
together
sit together and come up with the figure and file a report, a calculation.
fine.
sheet. How much time will you take?
so that kindly with that record chief accountant of both the parties not the parties
No, no, chief accountant was.
but 2 weeks 2 weeks after একসাথে বলবো
List after 4 weeks.
কোর্টের অর্ডার দিলে ঠিক কোর্ট অর্ডার
amount 22 লাখ যেটা বলবো লিখে দিন।
13.
My lord, I appear on behalf of the award holder in this matter, my lord. My lord will take, I have filed an application. Lordship will, I have filed this GA1. The orders are annexed to that application. Just for the purpose of showing the order, I'm just placing that application. Lordship will take the order at page 9.
Lordship, in this matter, first time we are appearing on behalf of the judgment letter number 2, Your Lordship. And we have been just engaged a day before yesterday. So the last time the direction was there to just file the affidavit of asset, Your Lordship. We are just seeking 1 week accommodation to file this affidavit of asset, Your Lordship. With this particular things, Your Lordship, the other aspects are there in which the section 12 compliance is not there, Your Lordship. And
that's not for me to see.
Your Lordship.
That's your 34.
Your Lordship. Your Lordship, we have already the 34 already just disposed of that.
But 34 dismissed as per my instructions are, my lord.
Your Lordship, it's a dismiss.
Then why are you saying this? If your 34 is dismissed.
I'm just saying, Your Lordship. 34 is already dismissed.
I will kindly take page 9 for
one thing, Your Lordship, in this matter.
Let them disclose which bank account they are maintaining, my lord, for this amount. This is an order of a court.
Amount. Where is the bank account? Which bank account are you maintaining? Give me the details.
I will give all detail, Your Lordship. For that, I am seeking only 1 week time, Your Lordship. We will give all the
last occasion, Mr. Ban.
We have been just engaged in
the
this
last
matter.
opportunity which it doesn't matter, sir.
Your Lordship.
It just doesn't matter.
I understand, Your Lordship.
Suppose your client keeps changing the lawyer, I should keep giving the time.
No, Your Lordship. First time I am appearing in this matter.
Not you. Your client is well aware of the orders passed by this court.
Your Lordship. That will not, Your Lordship.
This is just a way.
With this,
you're only delaying it.
No, Your Lordship. Right now, I am just seeking this 1 week accommodation only.
Kindly take page 10 for once. Page 10 of my application, then another order passed that in the absence warrant of arrest will be issued.
Go with the fact, Your Lordship. The judgment.
I have disclosed the name of the
Lordship
directors.
Goes into insolvency, Your Lordship, where they have lost the claim. And that claim is already admitted for execution. Your Lordship, how they can just come up with the for same amount?
Well, I can.
They want to recover with both the parties,
You have not filed your affidavit of asset. Let a warrant of arrest be issued. Let him be arrested.
Page 12 was the name of the two directors.
Your Lordship.
Page 12 I mentioned.
This for a very long time. It's since 2025.
Your Lordship, I understand.
One pretext or the other.
2024, my lord.
That's why I'm just seeking only
2024. Sorry.
No, not more than that, Your Lordship.
Within 3 days. File your affidavit of asset within 3 days. Keep it next week.
Your Lordship.
Learned counsel for the award debtor states that he has been recently engaged, though the conduct of the award debtor is deprecated. He has been seeking time for filing the affidavit of assets, and the same has still not been done. Full stop. 3 days is granted to the learned counsel for the award debtor to file his affidavit of asset. List next week. Thursday.
Grateful, Your Lordship.
Excellent.
Deeply obliged.
Okay. And now 14.
May it please Your Lordship. This is my execution application.
Before my learned friend starts, my lord, I'm being led by Mr. Jishnu Saha, my lord. He's on his legs in court 6, my lord. He was just here, my lord. Your Lordship may grant a short pass over, my lord.
If I may address Your Lordship, because Mr. Shaha has raised a preliminary point that this execution is barred by limitation. May I satisfy Your Lordship on that point of limitation? This is an award of passed on 29th of February 2008. Your Lordship will find that award
Yes.
at page 14, my lord. Be that as it may. My lord, may I just show what has been the change of law? My lord, this is the 96 Act before its amendment in 2015. My lord, will kindly take section 36. Here an application for setting aside was pending and is still pending. where the time for making an application to set aside the arbitral award under section 34 has expired, or such application having been made, it has been refused, the award shall be enforced. So while 34 is pending, I could not even file for an execution. This was the 96 Act. Now, my lord, this was really frowned upon by Supreme Court in National Aluminium. And the 246 Law Commission filed a report for amendment to the Arbitration Act. My lord, this is the Law Commission report. The page numbers are at the bottom of this report. Page 8, if your lordship kindly takes paragraph 3.
Yes.
The last 3 lines of that paragraph. After the award, a challenge under section 34 makes the award inexecutable, and such petitions remain pending for several years.
You're reading, just
Paragraph 3, my lord, at page 8. The page numbers is indicated at the bottom of the
yes. So where are you reading in this?
paragraph 3, last 3 lines, my lord, of that paragraph.
So this is against the ancestral
Yes.
model.
After the award, a challenge under section 34 makes the award inexecutable, and such petitions remain pending for several years. The object of quick alternative dispute resolution stands frustrated. Now, my lord, page 21, if your lordship kindly takes paragraph 34. I'll not trouble your lordship with paragraph 34. I will straight away take your lordship to paragraph 43 at page 25. Section 36 of the Act makes it clear that an arbitral award becomes enforceable after decree. So I could not enforce it because his 34 was pending. Only after the time for filing a petition under section 34 has expired, or after section 34 petition has been dismissed. That was not the case here. In other words,
Wait a minute. The way you are reading it, so there are 2 factions to it.
Yes.
One, the period of 34, 90
Yes.
plus 30, 120 days.
120 days. If they don't file it,
after
that I can enforce. If they file it within 120 days, I cannot enforce it till it is dismissed.
That's not how I read it.
But the section 36 of the Act makes it clear. If I may read once more, my lord. Section 36 of the Act at page 25, paragraph 43. Section 36 of the Act makes it clear that an arbitral award becomes enforceable as a decree only after the time for filing a petition.
No, that is not how it reads. We have to read this again.
Yes, my lord.
Where the time for making an application to set aside the arbitral award has expired.
Yes.
Right?
Or after.
Or. This is or.
Yes, my lord.
So there are 2 factions.
Yes. Either.
One, you file it after 120 days.
Yes.
All right. Or
120 days in case there was.
You are the clock starts ticking after 120 days.
After 120 days, yes.
So one is you file it after 120 days.
Right.
Or you are also entitled to file it after the 34.
After 34 is dismissed.
After 34 is dismissed, decide whatever it is. Yes, dismissed. So 120 days starts from, and the limitation period can be seen from that date. How are you saying it can't be?
But because if your lordship looks at the section 36 of the 94 of the 96 Act,
that's exactly what.
my lord, if I may take your lordship,
that's what I was
the trouble of.
Yes. That's what I was reading.
Where the time for making an application to set aside the award, arbitral award under 34 has expired. If it expires 120 days, I can file, or such application having been made. So if they make that application within 120 days, it has been refused. Only when it has been refused.
No.
Will kindly
or such application having been made It
has been refused,
The
the award shall be enforced.
which means 34 decided, dismissed, and after that.
That I can
So 120 days is the cutoff.
My lord, I will take your lordship through the Supreme Court decision also, Kochi Tuskers and all, has expired or after 34 petition has been dismissed. In other words, the pendency of a section 34 petition renders an arbitral award unenforceable.
That is
So
before 96.
that is before 2015.
Yes.
After 96 till 2015. That if there is a section 34 pending, I cannot enforce it.
Automatic stay.
It is an automatic stay. The Supreme Court in National Aluminium versus Press Steel held that by virtue of 36, it was impermissible to pass an order directing the losing party to deposit any part of the award into court. And I will not trouble your lordship with this. Now, these are the recommendations. If your lordship kindly takes page 56, this is the recommendation amendment. My lord, these are the recommendations to section 36, which was proposed by the Law Commission. And if your lordship kindly takes a note at the bottom of that, there is a heading with the note. The amendment is to ensure that mere filing of an application under section 34 does not operate as an automatic stay on the enforcement of the award. The Supreme Court in National Aluminium Company versus Press Steel recommends that such an amendment is need of the hour. Now, my lord, the question arose before the Supreme Court that in case of pending 34 litigations before 2015, whether 36, the amended provision of 36 will apply. So, my lord, may I just take your lordship through a decision of the Supreme Court in the case of Kochi Board of BCCI versus Kochi Cricket Private Limited. It is reported in 2018, 6 SCC 287. Paragraph 58, if your lordship takes, this was the question.
Yes.
Has your lordship found paragraph? From a reading of section 26 as interpreted by us, it thus becomes clear that in all cases where 34 petition is filed after commencement of the Amendment Act, which is, my lord, 15th of October 2015, 24th of October 2015. All cases where 34 petition is filed after the commencement of the Arbitration Act will be governed by section 34 as amended and section 36 as substituted. But what is to happen to section 34 petitions that have been filed before the commencement of the Amendment Act, which were governed by section 36 of the old Act? Would section 36 as substituted apply to such petitions? To answer these questions, we have necessarily to decide what is meant by enforcement in section 36. On one hand, it has been argued that enforcement is nothing but execution. And on the other hand, it has been argued that enforcement and execution are different concepts. Enforcement being substantive and execution being procedural. At this stage, it is necessary to set out the scheme of the 96 Act. An arbitral proceeding commences under 21 unless otherwise agreed by the parties when the dispute between the parties for which a request to be referred. I will not trouble your lordship with this. Then paragraph 60.
Yes.
This brings us to the manner of enforcement of a decree under CPC. A decree is enforced under CPC only through execution process order 21. As per 36(3) as amended, refers to the provisions of CPC for grant of stay of a money decree. This in turn has reference to order 41 rule 5 of the Code of Civil Procedure, which appears under the chapter heading stay of proceedings of execution. This being so, it is clear that 36 refers to execution of an award as if it is a decree attracting the provisions of Order 21 and Order 41 Rule 5 of the Code of Civil Procedure and would therefore be a provision dealing with execution of the arbitral awards. This being the case, we need to refer to judgments in order to determine whether execution proceedings and proceedings akin thereto give rise to vested rights, whether they are substantive in nature. Now, my lord, paragraph 62.
Yes.
Since it is clear, my lord, after setting out from Narhari Shivram Narvekar, paragraph 62, just after the quotation, has your lordship?
Yes.
Since it is clear that execution of a decree pertains to the realm of procedure and there is no substantive vested right in a judgment debtor to resist execution, section 36 as substituted would apply even to pending 34 applications on the date of commencement of the act. So Supreme Court says it will apply. Now, my lord will kindly note the date of this decision. The date of this decision is 15th of March 2018. It is at the top. Now, what the legislature does is in 2019, they come up with another amendment, which is section 87. If your lordship has the 2019 the 2019 Act after amendment, the latest arbitration. I can handle.
Yes. Yes. As a
To nullify this judgment, my lord, the legislature came up with section 87.
Yes.
My lord will kindly see. Unless the parties otherwise, and this came in on with retrospect, my lord will kindly see 87, and at the bottom, if your lordship will see, with retrospective effect 23rd of October 2015. This was to nullify the judgment in the case of BCCI. Unless the parties otherwise agree, the amendments made to this act by Arbitration and Conciliation Amendment Act 2015, 3 of 2016 shall not apply to arbitral proceedings commenced before the commencement of the Arbitration and Conciliation Amendment Act 2015, 3, court proceedings arising out of, also to court proceedings, which would mean 34, arising out of or in relation to such arbitral proceeding, irrespective of whether such court proceedings are commenced prior or after commencement of the Arbitration and Conciliation Act 2015. Now, my lord, this amendment was further challenged before the Supreme Court in the case of Hindustan Construction. My lord, it is reported in 2020 17 SCC 324.
Yes.
Paragraph 58.
Yes.
Equally, Sri Neeraj Kishan Kaul argument that section 87 is nothing but a rehash of section 26 and therefore in substance there is a direct encroachment on the judgment of this court but also be rejected. When contrasted with section 26, 87 is in two parts. 87A negatively stating that the 2015 amendment shall not apply to court proceedings arising out of arbitral proceedings, irrespective of whether such court proceedings are commenced before or after the commencement of the 2015 Act, and positively applying to court proceedings in case they arise out of arbitral proceedings that are commenced on or after the commencement of the 2015 Amendment Act. It can thus be seen that the scheme of section 87 is different from that of section 26 and is explicit in stating that court proceedings are merely parasitical on arbitral proceedings. It is therefore clear that only arbitration proceedings has to be looked as to whether 2015 amendment kicks in. It is therefore not possible to accept Sri Kaul's argument that in the present case there is a direct assault on a judgment of the court without first removing its basis. Then paragraph 59. This now sets the stage for examination of the constitutional validity of the introduction of section 87 into the Arbitration Act 1996 and deletion of section 26 of the 2015 amendment by 2019 Amendment Act against Article 14, 19(1)(g), 21 and 300A of the Constitution. The Sri Krishna Committee report recommended the introduction of section 87, owing to the fact that there were conflicting High Court judgments on the reach of 2015 amendment at the time when the committee deliberated on this subject. This was stated as follows in the Sri Krishna Committee report. I will not trouble your lordship with that. Then, my lord, paragraph 65. In the present case, the challenge is not to the fixing of 23rd October as the cutoff date, as the aforesaid date is the date on which the 2015 amendment came into force. For this reason, the aforesaid judgments have no application. Instead, what has been found to be manifestly arbitrary in the non-bifurcation of court proceedings and arbitration proceedings with reference to the above aforesaid date, resulting in improvements in the working of the Arbitration Act, being put on a back burner. The argument of the learned Attorney General must be rejected. Then paragraph 66 is important, my lord. The result is that the Kochi cricket judgment will continue to apply so as to make the salutary amendments made by the 2015 Amendment Act to all court proceedings initiated after 23rd of October 2015. Oh, my lord. And it strikes down 87 and the cutoff date is made 23rd of October 2015. So, my lord, if I take the cutoff date as 23rd of October 2015 and I can apply even if there is a 34 pending, because he has not filed any 36 to deposit the money under the award. The period of limitation for execution is 12 years. From 2015, I have filed well within the period of 12 years. Even if I don't take into account those 2 years of the Supreme Court.
Your 34 gets disposed of or?
34 is not yet disposed of.
It's still pending.
It's still pending. But there is no 36. That's what Kochi Tasker said. It will not, from today, it will not operate as a stay, automatic stay, even in respect of pending 34. You have to apply for under 36 for stay of the award. They have not applied, and I have filed my application within 12 years. In view of these decisions, my lord, my application is well within time.
No, but the applicability is from 2015.
But that's what Hindutva construction says, my lord.
But your award is of 2018.
2007.
7.
2008. 2008. No, 2015. It will apply. But 65 and 66
but
of
your
that.
reading in Hindustan is slightly contrary to what was there in Kochi. where it said that all proceedings which are pending, 34, the 36 will be applicable.
Made things very, very clear. I should show you, Lordship, the relevant part.
My lord, 65 and 66. It says, 66 says, the result is that Kochi judgment will therefore continue to apply, 66, my lord, so as to make applicable the salutary amendments made by the 2015 Act to all proceedings.
Yes.
So my cutoff date starts from 23rd of October 2015, 12 years. There is no stay. They have not filed any 36.
Very briefly, since your Lordship is looking at Hindustan construction, may I just request your Lordship to please have a look at paragraph 38 on it. Or please come to paragraph 33. The position is made very, very clear. Well, there were, I must confess, there were two prior Supreme Court judgments, one in the case of Nalco, other in the case of FISA. Both two-judge judgments. Both of them said that there is an automatic stay of operation of arbitral awards under the pre-amended provision of the Act. That fell for consideration in Hindustan construction. This is a three-judge decision. Please see paragraph 33. To state that an award, when challenged under section 34, becomes unexecutable merely by virtue of such challenge being made because of the language of section 36 is plainly incorrect. As has been pointed out here and above, section 36 was enacted for a different purpose. When read with section 35, all that section 36 states is that enforcement of a final award will be under the CPC and in the same manner as if it were a decree of the court. In fact, this is how section 36 has been read by a three-judge bench in Leela Hotels. It says, regarding the question as to whether the award of the learned arbitrator tantamounts to a decree or not, the language used in section 36 of the Arbitration and Conciliation Act makes it very clear that such an award has to be enforced under the Code of Civil Procedure in the same manner as it were a decree of the court. The said language leaves no room for doubt as to the manner in which the award of the learned arbitrator was to be accepted. To read section 36 as inferring something negative, namely that where the time for making an application under section 34 has not expired, and therefore on such application being made within time an automatic stay ensues, is to read something into section 36 which is not there at all. Also, this construction omits to consider the rest of section 36, which deals with applications under section 34 that have been dismissed, which leads to an award being final and binding when read with section 35 of the Arbitration Act of 1996, which then becomes enforceable under the CPC, the award being treated as a decree for the purpose. This also finds support from the language of section 9 of the Arbitration Act 96, which specifically enables the party to apply for a court for release after the making of an arbitration award, but before it is enforced in accordance with section 36. The decisions in Nalco and FISA developers and Intertrade overlook this statutory position. These words in section 9 have not undergone any change by reason of the 2015 or 2019 amendment. Then please see paragraph 37. This being the legislative intent, the observation in Nalco that once a section 34 application is filed, there is no discretion left with the court to pass any interlocutory order in this regard to the said award, flies in the face of the above opening words of section 9 of the Arbitration Act. Then you'll also see, my lord, paragraph 38. Well, thus the reasoning of the judgments in Nalco and FISA developers being per incurium in not noticing sections 9, 35 and the second part of section 36 of the Arbitration Act do not commend themselves to us and do not state the law correctly. The fact that Nalco has been followed in National Buildings Construction Corporation versus Lloyd's Installations does not take us any further, as National Buildings Corporation, in following Nalco, a per incurium judgment also does not state the law correctly. Thus, it is clear that the automatic stay of an award as laid down in these decisions is incorrect. The resultant position is that section 36, even as originally enacted, is not meant to do away with Article 36(2) of the Unscriptural Model Law, but is really meant to do away with the two bites at the cherry doctrine in the context of awards made in India, and the fact that enforcement of a final award, when read with section 35, is to be under CPC, treating the award to be a decree. Then when Kochi cricket is discussed, it will not trouble your lordship. Then please come to paragraph 41. Given the fact that we have declared that the judgments in Nalco National Buildings Corporation and FISA developers have laid down the law incorrectly. It is also clear that the amended Section 36, being clarificatory in nature, merely restates the position that the unamended Section 36 does not stand in the way of the law as to grant of stay of a money decree under the provisions of CPC. Now, my lord, this is, my lord, what is clearly held, my lord, by the judgment, my lord, in Hindustan Corporation. My learned friend has read from paragraph 58 onwards. My lord, that does not deal with this proposition at all. So, my lord, what this judgment clearly says is there is no stay of operation of, my lord, the award. It operates as a decree, and therefore, my lord, you cannot really say that, my lord, I was prohibited or precluded from filing an execution application. So, my lord, the time starts from 2007. The time does not start from 2015 as my learned friend pointed. Now, my lord, this position, my lord, was thereafter considered by a division bench of our High Court. My lord, may I just hand up, my lord, this judgment to your lordship? My lord, very recently, well, in 2026, your lordship will please see, my lord, the second paragraph. By the impugned judgment in order, the learned executing court found the execution of the award to be barred by limitation. Well, this was the issue. Then, my lord, please see paragraph 6. Relying upon the 2004-1 SCC 54, that's NALCO, then, my lord, National Building Construction, Lloyd's Installation, and FISA developers, and, my lord, host of other judgments. Well, lord, please see, my lord, just before paragraph 7, learned advocate appearing for the appellant submits that the doctrine of automatic stay was acknowledged and implemented both by the Supreme Court and by various high courts. Now, my lord, to this, my lord, please see paragraph 8. Learned advocate appearing for the respondent relies on 2020-17 SCC 324, that's Hindustan Construction, and submits that the doctrine of automatic stay was considered by the Supreme Court. Supreme Court negated such view, holding that the decisions on such court are current curia. In this regard, he refers to paragraph 30 of National Building Construction Corporation. Then please see paragraph 12. The issue as to whether there was an automatic stay in view of Section 36 of the Act of 1996 as prevailing at the time when the award and the application under Section 34 of the 1996 obtaining was considered by the Supreme Court in Hindustan Construction Company. Supreme Court, after considering various authorities, including National Aluminium Company, with regard to automatic stay under Section 36, well, it held as follows. I will not trouble your lordship. Then, my lord, please see paragraph 13. Hindustan Construction Company is categorical that automatic stay of the award as laid down in the previous decisions, including those cited before us on behalf of the appellant, were incorrect. It clarifies that Section 36, even as originally enacted, was not meant to do away with Article 36(2) of the Ancestral Model Law. It was really meant to do away with the two bites at the cherry doctrine in the context of awards made in India. Hindustan Construction Company specifically held in para 41 that NALCO and FISA, etc., laid down the law incorrectly. It is also of the view that amended Section 36 of the Act of 1996, being clarificated in nature, merely restated the position that unamended Section 36 did not stand in the way of the law to grant stay of money decree under the provisions of Civil Procedure Code. In facts of the present case, as noted above, the award was made and published in 2009. Respondent filed an application under Section 34 in 2010. Such application was disposed of in 2022. Appellant filed the execution proceeding resulting in the impugned order in 2025. The execution petition was filed after 12 years from the date of the award, dated 12th October 2009. We are unable to accept the contention of the appellant with regard to the automatic stay as advanced before us. Firstly, by the ground on which we cannot accept that contention is obviously binding precedent of Hindustan Construction. Another ground is that the conduct of the appellant itself, Hindustan Contract, etc. That is why we will go into. So, that clearly holds that, what my learned friend is trying to advocate, that it is from 2015 will be the cutoff date because that is when the amendment came into force, that does not operate. So, the execution application is clearly barred by limitation. Well, I just give you lordship the relevant
The
date.
same proposition is tested in this case also. If you here, para 11, appellant put an award of 2009 in execution on by the impugned order, or single judge had found, and this has been upheld.
Yes, no, the upheld, what was upheld was it was the execution application was dismissed.
Correct. That's what I'm.
Yes,
that's
exactly same proposition.
Same proposition.
Exactly same proposition. Exactly same proposition. Just for your lordship's easy reference, these are the relevant dates.
So what is left after this? The same.
Court clearly says that Kochi
No,
Tuskers.
have you seen this?
Yes.
This similar proposition, similar issue, barred by limitation.
But in another division bench judgment, where my learned friend had the privilege to appear, it has held to the contrary. I'll bring that judgment. Alok Saraf. Justice Bhattacharya held it to the contrary. The division bench. I'll bring that.
That's a different, but well, the Supreme Court is binding.
Supreme Court says, my lord, 23rd October 2015.
No.
It does.
3841 of Hindustan.
68. My lord, paragraph 68.
No. Para 38 of Hindustan is very clear to the extent that that's the whole idea.
Well, 38
Carry on the doctrine. I'm
38 onwards.
But kindly takes paragraph 65 of Hindustan. 23rd October 2015 as the cutoff date.
That's not correct.
And paragraph 66.
You have to read the entire judgment. You can't just
Paragraph 66 as well says the Kochi judgment will therefore continue.
Sir, the interpretation of Hindustan can't be read in one paragraph. It is very clear that it has to be applicable since prior to the amendment also, not from 2000. There's no cutoff date. You read 38.
65 and 66 also, if your lordship kindly
Read
consider.
38 also. Read 38. Thus, it is clear that the automatic stay of an award as laid down by these decision is incorrect. The resultant position is that 36, even is so and so, is not meant to do away with the Article 36(2) of the ancestral, which is really meant to do away with the two bites at the cherry doctrine in the context of the award. So it means that it's not the 2015 what you are reading it to be. And that gets
Kochi Tuskers, my lord, it was considered
that
and
gets strength from the division bench judgment.
even in Kochi Tuskers, it was held that it was an automatic stay. And it make the provisions of 2015 amendment applicable to pending proceedings.
Heard. The response have been filed, right? Heard, CAV.
The cutoff date is in 66, which says it's 23rd of October.
No.
But may I take back that? We're getting the old where acts are difficult.
It's very difficult to get it.
Unfortunately, my lord, these are, my lord, situations which suddenly confront us, and my lord, it is very difficult to, my lord, come out of these situations. We're getting run over by a bullock cart instead of an automobile.
CAV. Let me examine it all.
Hi.
I'll come back.
Item number 15.
May I please,
Lord, Lordship, in item number 15 and 16, I am appearing from the office of Senior Counsel, Mr. Manan Kumar Misra. Lordship, sir is in the Parliament, so I request you to kindly list this matter after 13th.
my lords, this is an award, my lords, of 7th August 2024. It's been almost 2 years, and today both 36-2 and 36 is listed, my lord, together. My lords, have asked them on earlier occasion that my lords have raised a question that my 36 execution is not maintainable. But my lords have also said that they are raising a technical
So we
issue.
have already attached the account.
My lords, but the
An application will release the money also.
my lords, their 36-2 is there. Let them deposit the money in court because the bank account does not satisfy the decreed awarded amount. The amount is in the bank, they do not have that much. That's the reason.
We'll keep it next week.
My lords, the council is probably appearing over here, my lords.
He's there online. He's requesting for a date on grounds of Mr. Mishra. So we'll keep it next
Can it be on Monday if possible, my lords?
Monday. It can't be, sir. Execution days are only. So we'll keep it.
Lordship, if possible, kindly list it after 13th.
Next week, my lords.
We'll keep it on the 13th. When is the last day out of the session?
I have no idea.
When is the last day of the session, sir?
Last.
Lordship, if possible, kindly put it on 16th.
When is the last date of the session?
13th, my Lordship.
16th, you will come on a Sunday. You'll come on a Sunday.
No, Monday, my Lordship.
Keep it on 20th.
20th then.
I'm grateful, my Lordship.
Learned counsel for the award debtor. Proxy counsel for the award debtor states that the learned senior counsel is engaged in the parliament. He prays for an adjournment parliament since the session is in process. The 20th August.
Gentlemen.
Yep. 15, 16 both.
Item number 17.
But this matter, I'm appearing for the decree holder. The RBI account of the government is already attached in terms of your lordship's order. Last time, my lord, we said that the amount can be paid directly from the RBI account. My learned friend appeared and said that I will tender the check, I will give the draft, and I will take instruction.
But on the 23rd of July, it's recorded, Lordship.
Yes. But I think, my lord, there is your lordship can direct the payment to be made of the attached amount from the account maintained with the RBI in terms of the prayer in the tabular statement.
Yes, sir.
You can pass it over just for 5 minutes because Mr.
Pass it over.
5 minutes, Lordship.
Who's appearing?
Mr. Loknath Chatterjee is appearing, a junior standing counsel. He's coming with instruction.
Who's appearing?
Mr. Loknath Chatterjee, junior standing counsel. Just 5 minutes.
May it be technical too.
There is no instruction necessary, my lord. The payment is attached.
Prayer B of the tabular statement.
Yes, I only passed that order on 18th.
Yes, ma'am.
Yes, my lord.
All right, pass over.
Pass over.
Pass over.
Listen, we can't have it today. There's a division bench at 2 o'clock.
Lordship.
We'll keep it for next week. Next
My lord, kindly direct, my lord, the account to be paid, amount to be
He's
paid.
just
My lord,
asking for a passover, Mr. Said.
well, let him come before your lordship's rise, my lord.
Let's see if it comes before 1:15. It's fine.
Yes. Oblige, my lord.
Great.
Pass over.
18.
18, I appear for the decree holder. Your Lordship, on the last occasion, we have submitted, my Lord, a supplementary affidavit annexing, my Lord, the original copy, the signed, stamped copy, my Lord, of the award as passed by the MSMED Council, my Lord. They have raised the point that it was an unstamped copy wherein the award was passed by the MSMED Council. So, my Lord, it was sent back by your Lordship's order.
Lordship, I'm led by Mr. Siddhartha Banerjee in this matter. Your Lordship, he is on his legs before the Honorable Division Bench of this court, praying for a day's accommodation, Your Lordship. We have been served with this supplementary affidavit.
Give me the supplementary.
But it has been on the last occasion, it
Fine.
was submitted, my Lord.
Fine.
Yes. आगे दिन दे दीजिए तो कोर्ट के हाँ my Lord, at page 6, my Lord, the stamp paper starts, my Lord.
Yes, it is, but it's not signed.
No, my Lord, my Lord, it is, my Lord, kindly see each and every page has been certified and signed by Pradeep Goswami, Deputy Director of MSME.
Please read my judgment. I have dismissed something like this.
My Lord, I'll come back, my Lord, come back. My Lord, in that case, if your Lordship, my Lord, so desires, again, my Lord, we have to go back, my Lord. Your Lordship can ask for the record from the MSMED Council.
No, ask for
The original copy will come before your Lordship.
You should write to the department, get the original copy, and then file the execution. I have dismissed the matter.
Very well, my Lord. We'll do that in that case. I will do that, my Lord. Otherwise, my Lord,
I'm not asking for
the certified copy as given by this honorable court. They are also, my Lord, the signatures are ST. If your Lordship kindly observes.
But I'll give you the link.
Very well, my Lord. I will, my Lord,
Get the
according to that judgment, my Lord, we will write a letter to the MSMED Council for issuing, for again, my Lord, giving a signed copy, my Lord.
You withdraw this.
My Lord, let it be kept pending, my Lord. May I be granted liberty, my Lord, to take back my original copy so that it can be sent back again to the MSMED Council for signing of the same.
So then you have to withdraw the petition.
No, my Lord, only the supplementary. Only the supplementary.
Even the supplementary, I'm not going to entertain till the time you don't really get it. Your execution petition as of today is not maintainable. That's what I've held. You can see the order next week. Just check that up.
My Lord, in the meantime, my Lord, kindly passes it for 2 weeks, my Lord. I will go back and obtain a signed copy.
2 weeks.
Yes, deeply obliged, Your Lordship.
Learned Counsel for the award holder, praised for an adjournment. Let this matter be stood over for till. Hand over till. Excellent.
Your judgment is also passed.
Item 19.
My lord, 19 is my application, my lord. My lord, on the last day, a point had been raised whether this court is a 2-1E court to file the execution application.
Yes.
My lord, I am supported by a 2018 judgment of the SCC, Supreme Court, and also, my lord, one coordinate bench judgment wherein Justice Bhattacharjee had held that wherever the assets are there, we can go and file there. In the affidavit of asset on the last day, they stated that they have an account in SBI, which is just beside the High Court within the original jurisdiction. Also, because it is a railways, my lord, they have an account maintained with the RBI, I believe, which is also within the original site jurisdiction. But may I just point out from the affidavit of asset, page 4, filed on the last date. Paragraph 5, the judgment debtors possesses the following assets.
Yes, then they are there in the. They have an account here.
We have an account.
Then it's maintainable.
There is a judgment to that effect. Well, otherwise, my lord, we are outside. And they had filed the.
No, otherwise also, my lord, Railways keeps an account in the RBI. RBI is within the.
Anywhere. RBI account is not there.
You have an account here.
They have said that we are outside jurisdiction.
You have an account here.
Yes, we have an account just next to High Court. They should have taken it out and filed it in Rajarhat.
No.
Where
Why
the section 34 is pending.
No, my lord, that.
Why should they? If
Anyway,
the
my lord.
account is here, they can file it here.
Well, there is no stay as on now. We have filed our 34 and 36.
36 has not been served. Stay application has not been served till date. I
So
believe.
we'll attach your account.
Yes, my lord. Also, my lord, kindly sees my tabular statement, my lord. The main dues are regarding.
Not even filed your affidavit of asset.
We have filed.
My lord, this is my lord,
This is the affidavit.
this is the affidavit.
So we'll attach the account.
My lord, may I just point out one thing, my lord. 2 fixed deposit certificates were deposited with them. If my lord takes up my tabular statement,
Yes.
my lord, amounting to rupees 36 lakhs 9,560 each. My lord, those two either they, my lord, I prayed in my tabular statement at prayer.
That can be done later on. Let the amount be secured.
My lord, at prayer, kindly says prayer I, that let those certificates be returned, or if they have encashed them, backside, my lord, prayer I, so A and B, two FD, those certificates they have to return them, or
Let that amount be secured, but let me take instruction regarding the fixed deposit.
I have mentioned that amount. That amount along with interest is 0.5 in column 7. It is 99 lakhs 32,818 for the fixed deposit.
No,
Let the total amount be attached,
without
because
the fixed deposit or with the fixed deposit?
with the fixed deposit is 1 crore 55 lakh 50,587.58. I am saying if they have not encashed those FDRs, kindly let me get them back. I can encash them.
Total awarded amount is 10,15,800. Right?
No, my lord.
Not 10 lakh.
1 crore.
1 crore 55 lakhs 50,587.58. In column 7.
One crore 55 lakhs, right?
Yes, my lord.
So we'll attach this amount.
Kindly attach 1,455 lakhs.
May just pray. If they can give it back, then that amount may be adjusted, and rest of the amount.
It will be subject to
But kindly
34,
do not
36.
pass any order regarding the fixed
No,
deposit.
I'm not passing any order regarding fixed deposit. That's your performance guarantee and all that.
Yes.
If I return that, then the 34 is still pending.
34 is pending.
We'll acha, very good. We'll make the proper application.
What I have no
Oh, amount 36.
The
awarded amount is
affidavit of asset filed by the
2 lakhs.
No, into 2.
by the
Multiplied by 2,
awarded
that is only for the amount on the basis
indicate
of the 2 fixed deposit. The total amount is 1.
that they have a bank account
Puro calculate kora ache.
with the SBI Bank, Kolkata main branch, IFC यहाँ से ले लो ये पूरा account number so and so. The same is attached to the extent of rupees 155,50587.58 in terms of the award. There are two parts of the award.
Yes, there are two parts. There is the first part is the money award and then security deposit.
Award.
FDR.
Award in terms of the award.
The award is 49 lakhs 99,154.
In terms of the award.
Because if they win, they get back the money or the fixed deposit. My lord, 155 is good enough.
The ground raised by the awardator. Awardator does not press.
No, kindly do not press. My lord passes the order saying that since the account is there, this is maintained.
The awardator on the last date had raised an objection to the maintainability of the execution petition on the ground that this court is not the 2-1E court in terms of the Arbitration Conciliation Act 1996, full stop. Since the awardator has a valid bank account existing within the jurisdiction of this court, the argument advanced by the awardator is rejected. उसके बाद कर देना.
First, my lord, this, then
And then record this, that the account so and so and attached to the amount tune of funds in terms of the award. All right.
Grateful.
But, let this be pending, my lord. The execution.
Execution is pending. I'm not dismissing it. List after 4 weeks, 6 weeks. Year 34 and 36 are still there, right?
So 8 weeks, my lord, will be
No, no, let
Or
it
6
be after
weeks.
the vacations.
6 weeks.
6 weeks.
My lord, Mr. Chatterjee is here now. Serial number 17, my lord.
Yes, call that one.
First of all, matter item number 17.
Yes.
My lord, there, my lord had been pleased, my lord, to pass an order upon the RBI, my lord, to attach, my lord, the sum. My lord, now that
Attach
the
and debit,
SFBs,
my lord. That was directed.
my lord, now, my lord, that the RBI has done. So, my lord, we tried to take instructions. So, my lord, they were not, they were yet to ascertain, my lord, whether the RBI had done with the attachment
Yes,
or not.
yes,
So,
it
it
has
would have
been
been
done. It has been communicated to us that
My
they
lord,
have complied with
my
the
lord, now that, my lord,
attachment,
we will,
but not the
there, my lord,
debit.
it has to go through that attachment process, or my lord, we will have to.
So that's what you were supposed to take
No, my lord,
instruction.
we sought instructions on that attachment portion, my lord. They were not being able to, my lord, ascertain it.
That's your account. You don't even know whether it's been
My lord,
attached.
it's a large
Lordship,
account.
the RBI has informed the award holder that they have attached it, but the debit has not been done yet. Lordship will direct
What
the
you were
RBI
supposed
to
to.
debit the amount.
But
as per
that
the
is
The amount will be debited only, nothing else.
Oh, Shakur.
Yes.
So, my lord, yes, that my lord, whether they were yet to ascertain, my lord, they couldn't ascertain whether RBI.
You were supposed to ascertain how will you make the payment.
Yes, my lord.
You forget about the RBI. You were supposed to come back today and tell us how are you making the payment.
My lord,
Tell me.
My lord, on that aspect.
What is your instruction?
My lord, on that aspect, my lord, specific instructions, my lord, we are yet to receive because they've not been able to ascertain. That is the only difficulty, my lord. My lord, we have communicated, my lord. My lord's
No
order.
way to deal with matters.
I understand, my lord. I bow down.
No way to deal with matters.
I understand. I understand. My lord, this.
Take down. Learned counsel for the award debtor had sought time from this court to take instruction as to how they will comply with the award dated 19th May 2018, since the award has attained finality and award has attained finality. Full stop. No instruction has been received by the learned counsel for the award debtor. Full stop. The sorry state of affairs with the state is evident from the conduct of the award debtor. Full stop. This court, by order dated 18th December 2025, had attached the account of the award debtor existing with the Reserve Bank of India to the extent of rupees 13149,014.00 as the full and final satisfaction towards the decretal dues. Full stop. Since no response is forthcoming from the state as to how they will comply with award dated 19th May 2018, which has attained finality, this court is constrained to direct the RBI to release the amount attached, the amount of rupees 13149,014.00 lying with the state of West Bengal to be released in favor of the award debtor within a period of 2 weeks, I guess, Mr. Sen.
Yes, Lord. Yes.
Within a period of 2 weeks, the satisfaction of the award / the decretal dues in favor of the award holder. Full stop.
But earlier,
My lord, my lord, my lord, at times, my lord, I understand, my lord.
You
at
have been
times-
taking time.
No, my lord, yes, my lord, we had on the last occasion, my lord, it had fallen from my lord as to how we will have to satisfy.
Why should they suffer? You have lost it till the Supreme Court.
Yes.
Now
We,
the
my lord,
award will
they've
not get
exhausted
executed.
all avenues as far as challenge to the
Then
award.
why
is
are you not making the payment?
No, my lord, now the only modality, my lord, they were yet to ascertain whether RBI attachment has been, my lord.
You had come here last time. You had
My
appeared.
lord, we were there. We were there.
You took time to take instruction, and you have no instruction today.
My lord, we sought the only.
What do you mean you sought?
We sought instructions. My
What
lord,
do you mean you sought instruction?
from my lord the department, my lord.
Then what happens?
My lord, now, my lord,
You're not able to get the instruction.
my lord,
All right.
they were
Someone's released. That's all.
I think in it had gone down award debtor in one portion. Your lordship will kindly check.
Award holder.
Obliged.
Lordship, by way of check, Lordship will.
Demand draft.
Demand draft.
Obliged.
my lord has been pleased to, my lord, dispose, my lord, the.
Yes, dispose of.
Yes.
Not 20. My execution application in this matter, Lordship, passed an order of attachment. The order was passed on 8th January 2026. Now, in this matter, there is a 36-2 application
Yes.
in which a direction was passed by your Lordship, giving them liberty to deposit the amount within a certain period, failing which the respondent shall be at liberty to execute the award in accordance with law. This is the order of.
Page.
This was passed after your Lordship had passed the attachment order. They came up with an application. Now that deposit has not been made. And Lordship's attached by your Lordship's attachment order, this is what we received from the Reserve Bank of India.
This must be before the government changed.
I'm sorry.
This is
First
before.
time, my lord, this is coming up, my lord.
No, this is not the first time.
My
Third
lord,
time
no,
he's
no,
taking
my lord,
time.
First time we are.
Third time he's taking time. On the last occasion, he was there. I was inside the card. That is why. That is why. Let my learned friend not take.
No, it's not about that. My lord's last order was of 11 June, my lord.
Yes. This is the third time he's taking time.
No.
Where were where?
On the last occasion, there's no order pass. I was personally present.
How can it take time? This is the order of 12.
On the last 2 weeks ago, the matter was again called on. When I was sitting in the car, Lordship said not to do the matter, and he was there in court.
He was in car, my lord. My lord did not allow him to appear from the car, my lord.
He sought time. He sought 2 weeks time.
Yes.
He sought 2 weeks time.
My lord,
Otherwise, the matter would have been there in the last.
Take instruction.
Lordship, that time period is already over.
Let him take instruction. The government has changed. Learned counsel for the. This is your 36 application.
No, this is my execution application.
I know this is your execution. You have already been secured. Account has already been attached. What do you want? Payment to be released.
As per your Lordship's order was.
What is the status of your 36? This is not today. Keep it after 2 weeks.
Lordship is not passing anywhere.
After 2 weeks. Take instruction. Rest of the matters after that. But since now you have become the counsel for the state, at least get these matters updated.
My lord,
you're not even having instructions.
My lord, suddenly, my lord, this has all of these, my lord, with the department also, my lord, there has been some churning, my lord. So this is, my lord, we are trying, my lord, because many matters, my lord, these are serial, my lord, with due respect, serial litigants. My lord, they have matters spread, my lord, section 34
This is
there.
execution petition, sir.
My lord, yes, my lord, these are section, my lord, then there are section 34, not all matters, my lord, we've also been able, there are some section 34 spending, section 37 spending in some matters, my lord, so we are not even updated on those, my lord, we will, my lord.
First, we'll take the contempt application.
Appellate side matter, item number 1.
Lordship, in this matter, Mr. Ramdulal Manna is appearing for the petitioner, Lordship. Today morning he has fallen, Lordship, and got injured. I am praying 2 weeks adjournment, Lordship.
But I submit, my lord, I have not object. I can
Lordship,
file my
item number
opposition.
1, 2,
Lordship,
3.
Supervision directed me to file opposition. May I file it, my lord?
Is your reply ready? File
No,
the reply.
They have not yet filed.
Then, madam,
Kindly give me 2 weeks adjournment, Lordship. Reply has not been ready.
And so far the item 1 is concerned, your lordship will find for the
that's
last
the
order.
contempt.
Their opposition has been filed. Your lordship ask my lord to file opposition next 2 matters, my lord, 2 and 3. So far 1 is concerned, my lord, opposition filed, they have not filed reply. Your lordship kindly pass order to that effect, my lord, they are supposed to file reply within 2 weeks, subject to correction by your lordship.
Lordship, reply will be filed on the returnable date, Lordship. Kindly fix the matter.
That affidavit in opposition is on record. Yours. Just give it.
1 is already filed. Now 2 and 3 is
So in 1 we'll record learned counsel for the petitioner seeks and is granted. How much time, madam?
2 weeks, Lordship.
2 weeks time to file her reply to the affidavit in opposition. List after. After 4 weeks. Good.
Grateful, Lordship.
Anail Almighty. Item number 2. Yes. But filing, my lord, opposition to the contempt application, section 5 application, and my lord, substitution application.
ট্যাগ আছে ট্যাগ আছে তো অল্পটা আলাদা করে দেবেন একটাই অর্ডার শিটে সিপ্যান 1975টা প্রথমে করবে ওটাতে সাহেব যে অর্ডারটা দিল 1976 তারপরে 1977 হ্যাঁ হ্যাঁ এটা খালি রিপ্লাই হয়ে গেল অর্ডারটা ওর অপোজিশনটা ফাইল করছে আজকে দুটোতেই Mr. Bhattacharya, opposition in both 1976 and 1977.
I'm giving one but one after another.
Yeah.
So that it is not mixed up. Yeah. Opposition to the contempt application, opposition to this section 5, and opposition to the substitution application.
Can 2 and can. Affidavit in opposition to can 1 and can 2 filed by the respondent is taken on record. You want to file your reply to them?
Yes, Lordship.
Learned counsel for the petitioner seeks and is granted 2 weeks time to file her reply to the said affidavit in opposition filed by the respondent in can 1 and can 2.
So 3 sets of affidavit.
Yes.
In every 3 sets.
Yes.
Contempt, can 1, can.
Now the 3.
Number 3.
Number 3.
Same order in.
Yeah.
Grateful, Lordship.
Yeah.
কন্টেমনার ভালো কথা এক দুই তিনে পিটিশন
Lordship, 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 I have received the copy in item number 2 and 3. Item number 1, I have not received the copy of the opposition.
Item number 1, opposition has already been filed. It's on record. You're out of time to file the reply in item number 1. So we have extended the time to file the reply by the returnable date in 3 weeks' time. Matter will appear on September 3rd.
Great.
Good. एक फाइल पे देखिए
একটা পার্টি পাঠাও তার মধ্যে না সবকটা অপোজিশন না সবকটা অপোজিশন একটা মধ্যে যা যা ফাইল রয়েছে আর আমায় দেখে নিতে হবে বুঝেছো
Item number 4.
My lord, in this matter, I am for the petitioner, my lord.
Oh, my lord, I am appearing for the alleged contemner.
My lord,
In the meantime, the board has dissolved and the chairman has resigned also.
my lord, and
Yes, sought for it.
and executive officer was appointed as administrator of Bolpur municipality. My lord, leave may be granted to file appropriate application.
If your lordship
Who is the contemner?
contemner was initially chairman.
Chairman of the Bolpur municipality.
Being resolved doesn't absolve him.
My lord, your lordship can take it on the merits. But
Of course, we'll take it on the merits.
she has resigned.
Yes.
But then, Lord, I informing it.
My lord,
Lordship
Will not absolve him
Lordship will take
from the acts of contempt
My
if
lord.
we find it.
No.
my lord, kindly
New incumbent needs to, if there is at all any compliance
Yes.
necessary, if your lordship kindly sees the order, how the contempt lies, my lord, subject to your lordship's.
That's a different issue.
my lord, kindly come to page 34, my lord. Initial order passed by my lord Justice Kaushik Chandra, my lord. That order was modified by the division bench. That is why, my lord, lordship kindly come to page 34 first. Page 34. May I read what, my lord? Read out. My lord, page 34, my lord. The deceased mother of the petitioner made a representation before the Bolpur municipality to allow her to construct a drain system for outflow of water from her premises. Such prayer has been opposed by the respondent number 6. It has been submitted by the respondent number 6 that the nature of the relevant land is sally. The petitioners cannot make any construction on a sally land. That was, I am denying, but it was not sally land. The municipality submits that the drain should be constructed by the petitioners themselves. The municipality cannot construct a drain on the petitioner's land. I do not see any justification in the stand of the respondent number 6. If the petitioners construct a drain on their own land, which is essential for a healthy living and to prevent waterlogging, respondent number 6 cannot have any objection. In view of the aforesaid fact, I dispose of the writ petition by permitting the petitioner to construct a drainage system for drainage of waterways from their premises. The municipality shall grant the necessary permission subject to deposit of necessary cost, if any. I, however, make it clear that in undertaking the construction work, the petitioner shall not encroach upon the land of respondent number 6 or cause any inconvenience to him. This is the order, my lord, passed by my lord Justice Kaushik Chandra. Against that order, my lord, private respondent filed appeal, my lord. And the appeal court order, my lord, kindly come to page 38, start from 38, page 39 is the actual order. My lord Justice Jaimal Bagchi, as his lordship then was, and my lord Justice Kant passed the order. My lord, paragraph 4 is the relevant portion, page 39. We have considered the materials on record. There is no dispute that the respondent number 6 to 9 writ petitioners are entitled to construct a drain in their own premises subject to permission from the municipality concerned. However, such construction cannot be made on a public land or private property or on any common passage over which the third party has a right to easement. Prior to grant of sanction for constructing a drain in the premises of respondent number 6 to 9 writ petitioners, municipality concerned must bear in mind whether outflow
of water from the drain would adversely affect public use of the pathway and or other common amenity. Municipality should also ensure that the said construction is in with the sewerage work of the municipality concerned, my lord. That order, my lord, I communicated through my letter dated, my lord, page 37. Page 37. Thereafter, my lord, again I made another application, remainder application, page 48. Municipality did nothing, my lord, neither inquired the matter, nor informed the petitioner, nor take any steps, my lord. And my lord, my water from inside of the house is not, my lord, I am suffering, my lord, rainwater and wastewater of my premises. There is no drainage. Petitioners want to construct drainage on his own land, outside his.
For the division bench order, the municipality
Should-
was liable only for two counts.
Yes.
First is that they have to give you the permission to construct the drain. Second, they are to ensure that the water from the premises does not flow out in a untoward manner so as to affect public health.
Oblige, my lord.
These are the only two things.
Oblige, my lord.
Yes, they have not done that according to you.
Nothing.
Neither of the two have been
No.
done.
But page 45 is their plan sanction. He is to construct a drain in accordance with this sanction plan.
No, at that time, no drain was
So
constructed.
he has to apply for the
That is why I am
permit.
that is why I am submitting.
There was an issue with the private respondent and the petitioners. Now they are not allowing each other to construct the drain. Now the sanction plan we submitted that we cannot construct the drain. He is to apply for a permission in accordance with law. He will get the permission and he will construct.
I applied page 45, my lord, with my letter, my lord. Kindly see my letter, page.
No, page 45, my lord, according to my instruction,
page
this is the
37.
sanction plan.
Page 37.
Now let him construct the drain.
Without permission of the municipality, how can I construct my drain, my lord? Without granting permission by the municipality,
He's giving permission.
my lord.
No, whatever is there in page 45, my specific
You have to take a stand. You can't say one way you are saying that no, this is the sanction plan, let them construct. Then you are saying
my
no, whatever
instruction is, my lord, page 45 is the sanction plan. Page 44 is not the sanction plan. I have a specific instruction. Page 44 is not the sanction plan. Page 45 is.
show us that you told them, intimated this to the petitioner.
I have not intimated it to the petitioner because
Nothing.
my lord, there was no direction. My lord, it was upon them to construct the plan.
No. Come to page 34, last but one paragraph.
My lord,
Page 34.
page 34. Page 34 is the Honorable Single Judge's order.
Yes.
Lordship.
To the last but one paragraph.
The municipality shall grant the necessary permission subject to deposit of necessary cost.
Right.
He has not, no.
I applied. Municipality did not allow to deposit
Let him
cost
show.
or.
Now, this is my lord.
My lord, kindly see my application, my lord. Letter, my lord.
Let him apply
Page
for
37.
permission.
Page 37, my lord. Page 37. Categorical mention.
Is this a lawyer's letter?
For the order of single bench, division bench, and the proposed plan of the drainage to clear the wastewater.
When is your application to the, you have to apply to them. If you don't apply, how will they respond? If you apply, then you have just sent copies of the orders and then
My lord, apply. My lord,
the form. I'm sure there's a prescribed format.
my lord,
fees which you have to pay.
my lord, kindly see. Start from page 24, my lord. Start from page 24. No, my lord. Before that, my lord, also. Before that, also. Plan is page 20 and start from page 21, my lord. Since 2017, I separately made an application.
Order is the division bench order is
Yes,
of
ma'am.
6th of August 2024. Show us a letter post that. End of the matter.
After that, I communicated the division bench order as well as single bench order with a request to grant permission.
Where is that request to grant permission? Show us. Post the order of the division bench.
Page 32 onward, my lord, order, communication, and my lord, on me.
Sir, I hope you understand
Yes,
what is
madam.
falling from this bench is that this order has been passed by the division bench as well as the single judge, but where have you taken any steps
Yes,
in
madam.
furtherance of the orders passed by this court, whereby you are supposed to give a plan or an application to the concerned municipality for sanction
Plan,
with the requisite fees. Where is that? That's what we are asking you.
plan was,
Plan which you are showing is an earlier plan prior to the passing of the orders by this court. After the orders have been passed by this court, where is the steps which you have taken to communicate the plan which you want to be sanctioned? Where's the application? Where's your application?
there is no proper application, but
So, sir,
my
then
lord,
how,
but my lord, one
wait
thing,
a
my lord,
minute, sir.
one thing, my lord, kindly come to page
How
40.
are you alleging contempt on their part if you have failed to comply with the order which has been passed by this court?
My lord,
The order is specific to the extent that you are supposed to communicate, seek an approval of the plan. Where is the letter which you have written or an application which you have filed before the municipality seeking permission from them? You please show it after the order.
my lord,
And if you have not done it, then you withdraw it, move an application, and if they don't consider it, come back to this court. But
Yeah.
as of today, there's no
then, my lord,
contempt.
grant me such liberty, my lord.
All right. Learned counsel for the petitioner has preferred the present contempt petition, alleging willful disobedience on part of the respondent in complying with the order dated so and so, passed by this court in MAT 1431 of 2024. It is the case of the petitioner that the respondents have not accorded, or the respondents have failed to comply with the directions given by this court. Full stop. This court observes that the petitioner has not made any representation or given any plan before the municipal authority to take any steps in accordance with the directions passed by this court, wide order dated so and so. Full stop. The present contempt petition is bereft of any merit at this stage, since the petitioner himself has failed to comply with the directions passed by this court in so and so. Hence, no contempt is made of the present petition.
My lord, liberty may be granted, liberty may be.
Liberty to the petitioner to file appropriate application. And then again, contempt dismissed. Contempt is dismissed. You already have the liberty. Order is
My
already
lord,
there.
liberty may be granted. My lord, kindly,
Sir, liberty
my
is
lord,
already there
kindly,
with you.
without liberty, my lord, municipality will not take steps, my lord. My lord, I am facing since
Sir, wait a
since
minute.
2017, my lord, I am facing
Wait a minute,
difficulties.
sir. The contempt is only dismissed. You withdraw it. I will not even dismiss it. इसको change कर दो. Learned counsel for the petitioner seeks to withdraw the present contempt petition at this stage with liberty to approach this court if the need arises at a later date. The present petition is dismissed as withdrawn.
Okay. Oblige. My lord, there is no board, my lord, at present, my lord, executive officer, my lord, is
Sir,
a administrator.
An application, if they don't comply, come back to us. We will ensure our orders are complied with.
Executive officer is discharging.
Executive officer is the administrative.
He's discharging the function.
Yes, madam.
As an administrator.
As the
As a-
administrator.
Yes, madam. There is no board at present. That is, there is no board at present.
Yes.
File a separate rate.
Item number 5 and 6.
After the respondent in this review.
Yes.
No, I আগে ওটা হবে তারপরে এটা হবে।
5 is my contempt application.
First, we'll deal with the review.
Yes, my lord. Yes.
They're together, no?
Yes,
So tag করা আছে।
No.
5 and 6 tag করা আছে।
You are seeking contempt of which order? The directions?
Contempt of the order which was sought to be reviewed. Which is sought to be reviewed before your lordship.
So we'll deal with the review first. Yes.
Now, my lord, in the review, we are in a very inconvenient position. For the municipality, I appeared. I argued before your lordship also in the earlier division bench. Now, Mr. Shaktiraj Mukherjee, learned senior advocate, has been appointed by the state to support my cause. Now, my lord, thereafter, after the change, alteration of government, my lord, learned senior who was supposed to assist to and go to Mr. Shaktiraj Mukherjee, Sri Ansar Mondal, additional government pleader, is no more in the panel. He is no more additional government pleader. So I will have to take the responsibility and we will have to inform the state to place someone in place of Mr. Ansar Mondal and a junior advocate. Then we can approach Mr. Shaktiraj Mukherjee. It's a very awkward situation, my lord. We tried, I tried my best. I took the initiative.
This is the review. You appear for Rajpur Solarpur. Huh?
I appear for the municipality.
This
I
is
argued
the review
the
filed by the municipality. This is
yes,
the review
yes.
not filed by the state.
No. Review has been filed at my instance by the municipality, correct? But state has agreed.
But state has no role.
Yes.
Not only agreed, I let
State has agreed.
একটু জজ সাহেবকে দিন এটা
State has
your
agreed
lordship
for
kindly
what?
see your lordship kindly see what is on record. The state, it is of course that it's on record that I have filed the review, but the state government has agreed in consonance with my opinion that I need a support, a serious support, legal support from the state, and for that matter, in an exceptional circumstances, Mr. Shaktiraj Mukherjee has been appointed. I have my own argument, but still I wanted someone.
Review is filed by you.
By me?
So you defend the review.
Yes, I will, but I require a support from the state to reinforce my case.
Yes, sir, you are good enough.
No.
Support.
My lord, I will argue for 5 minutes. Even I can argue now. I have only one point. A legal principle. Yes, I can tell it. Ultra petita. I put it on record. Ultra petita, except that I have no case. Ultra petita. That when the application was not on record, the review application, an application for recalling of the order was treated as review. My argument is the first bar is review is a separate, independent, prescribed application under Calcutta High Court. It requires a specific fee also. It's a separate application. So, by no means the court should, I say, High Court can, but should convert an application for recalling as review. Because review application was not on order. Then this become perverse, not supported by record. This is my argument. This is called ultra petita. I will bring the judgment. Ultra petita means beyond the prayer. The prayer was not to allow the review. Your lordship was pleased to dismiss the mandamus appeal. Then an application for in presence of the respondent. Then an application
To challenge that order.
where?
Yes.
In Supreme Court.
Yes, in appeal you should have challenged that. Go to SLP.
No. Why?
And ask for a review of that.
No. This was
Sir, what
yes.
had happened?
My lord, kindly
There was
appreciate
an
for a
order.
minute. I finish it. My lord, I will not disturb or
So you
waste
can
your
talk
lordship's
20
time.
minutes. No problem. You're not wasting even a single
No.
minute.
I make it very brief.
Sir,
Now, my lord, my opinion was first to file a review. My lord.
Why don't you listen to what my lord has to say?
No. I of course I have.
No. Please listen to what he is saying.
the order which you are challenging is of 1st of October order.
1st of October 2024.
Review has been disposed of by the 23rd of September order. Right?
Yes.
That you failed to challenge, but your entire grievance is against that order. That is the order which you are saying is an illegal order.
Yes, my lord, but with my ground.
Not challenge that order, sir.
Yes.
You are challenging the order which has been
Final order.
by which the appeal has been restored and then heard. Today you are challenging the final order.
Final order. In review.
Even my lord,
In review.
In a very limited scope. Yes.
even my lord,
Just
that
a
order
minute.
has not been challenged in this review application.
You
Highly
should have challenged that order with which you are aggrieved that there couldn't be any order passed because it was not review per se in terms of the whatever, the High
No.
Court rules or whatever.
My lord, if your lordship.
Have you challenged it? You didn't challenge it.
No. I challenged.
That order you have not challenged.
The order.
Challenge the final order.
Final order. Yes.
You have not challenged the earlier order with which you are you are aggrieved. You have not challenged.
No, I am aggrieved by the appeal order, last order. The last order.
Last order is in conformity with the earlier order which has been passed. By
Okay.
that 23rd order, the review has been allowed and the appeal has been restored, and then the matter has been heard and the final order has been passed.
Yes.
You are aggrieved by the order passed on 23rd of September, whereby the review has been allowed, where you say that there was no application for review which was pending, and that is a wrong order which has been passed.
No, then I will have to abide by. During argument, my lord, I will disclose that. But finally, I have even said to you, I have submitted to your lordship what is my point. Now, I require say support. The state government agreed with me, and they have the state has engaged Mr. Shaktikanth Mukherjee. The difficulty is, since Mr. Ansar Mondal is no more additional government leader, we have to take initiative.
My brother tells me that Mr. Mukherjee was not coming to the court from after COVID.
No, I know he
What
will.
support are
He
you-
will appear.
Sir,
virtually.
you please tell me what support are you looking at from state? On the ground of state, why are you taking date? It's your application.
I am not taking adjournment on behalf of state.
Yes.
Now, nobody is represented by the state
That's
since
their
the
problem.
AGP has retired.
That's-
Sorry, the AGP has.
That is their problem. That's not your concern. That is for the state to deal with their own cases. Today, you are for the municipality. Your concern is with this application. How are you concerned with the state?
But, Milord, the state also, the department has also communicated to me.
That's their problem.
It is a fact that the officer who passed this GO is no more with the department also. He is also transferred, Mr. Jolly Chaudhary.
We will record the state is not represented. That's it.
But, Milord, the state presently does not know the status of the application.
That
The
you
all
should
records were with
if
Mr.
at all-
Ansar Mondal, AGP.
Mr. Mukherjee, if at all you had to bring out all this, you should have done it prior, not today. Today, we are only listening to your application, which is on record. We are not bothered with the state.
I know, my lord. Your lordship can. Your lordship is.
We are not bothered.
I know your
They
lordship
are
can.
here, they are
Very
not
much.
here. It is their concern. Any matter which is listed in our list, the state has to come. And if they don't come, we pass an adverse order. We are not concerned with the state. What kind of support you are looking at, you tell me. Because we don't need the state here.
Milord, there is a point. Since I am not arguing, I am not escaping, Milord. Neither I want to delay. No. Your lordship, kindly do not think that I am delaying the matter. Never. But this is an inconvenience which, Milord, I am facing because I was orally requested by the state, the department of the officers of this department to take initiative to engage Mr. Mukherjee. In the meantime, Milord.
Mukherjee is not coming.
No. He will appear virtually. This the primary conversation has been done.
So you need the state for what purpose? To build on your argument? The state
It is the wish of the state also, my lord.
Doesn't get reflected. If the wish of the state was there, then they would have called somebody.
Because of the change of government. I will have to find out who is holding the brief on behalf of Mr. Ansar Mondal.
You should have done that exercise prior to this date.
Yes, my lord. For this I can be accused. But the state of affairs is this. I do not know whom to appear. Whom to contact.
The election panel, all have been there for months now.
I cannot say, but still your lordship is aware that in many courts.
You have the advocate general, you have everybody. Sir, don't say that.
My lord, it is not so easy to go to
It is
advocate.
not so easy
I
to
am
have
not
the
a
division
state
bench.
advocate.
These are special division benches.
Yes, I
which
know.
are constituted. It is not so easy for both of us to find a date when we can sit, because we both have our independent rosters also to handle.
So your
For
lordship,
the bench also
your
it's
lordship kindly give me a date. In the meantime, if I succeed, I will do, or otherwise I will do it myself. The argument I have made, your lordship. I will not take more than 5 minutes.
Learned counsel for the petitioner states that he is in some personal difficulty and seeks an adjournment. Let this matter be listed on 3rd of September for arguments.
3rd of September. Obliged.
এই কন্টেম্পটে তাহলে কোনো এটার বিরুদ্ধে এটা রেকর্ডে রাখবেন না।
So both the matter. Both 5 and 6. So, एक और है. Hey, there's one more matter.
Item number 7.
This is my contempt application, Lordship. After filing the contempt application, Lordship, contemptor.
I've complied.
Yes, Lordship.
All right, learned counsel for the
No,
petition.
Lordship, after filing the contempt application, Lordship, contempt filed one compliance order, Lordship. I will file the exception against the compliance order.
Show me what is the compliance. It's on record, or only copy has been given to you.
Yes.
Who's the contemptor here?
SDU, Lordship,
At the direction.
Purbo Vidnapur.
Right. The unauthorized construction has been removed. They are saying they have complied with the order.
Lordship, against this order properly not comply, Lordship. Against this order, Lordship, I filed the exception, Lordship. Kindly, I pray for time, Lordship. Filing the exception. Without plan, Lordship, they are constructed.
Demolished it.
No, Lordship, not properly demolished, Lordship. Lordship, I filed the exception, Lordship. I will file the exception, Lordship. That's why I pray for time, Lordship.
You are appearing?
My Lord, I am appearing in connection with Mat 1578 of 2024.
The matter? Who are you appearing for?
Lord, that has been tagged with, Lord. It has been already decided on the 11th September 2024. I am appellant there, Lord. Lord, no copy has been hard upon me, my Lord.
You are the private respondent?
No, my Lord, I am the appellant in 1578.
One 1578 is the
disposed of.
The contempt arises out of 1578, sir.
Not the 1578. I am the appellant, Lord.
I am the
disposed of.
petitioner, Lordship.
That has been disposed
11th
of.
September 2024.
Disposed of, not my Lordship. They are directed by the Justice, Lordship.
Just a minute.
Within
For
2
the
minutes,
appellant.
within 2 months, comply the order. That was not done. That's why my client filed the contempt petition, Lordship. In the appeal, Lordship, I am appearing for the respondent, Lordship. Rajiv Lochan Panigrahi and Shiva Prasad Panigrahi, Lordship.
It's a family dispute.
Yes, Lordship. Already filed the
brothers.
partition should, Lordship, and there are
Partition suit is pending, my Lord.
Lordship, I will file the exception, Lordship, against the compliance order, Lordship.
Lord, I
pray for life.
Lord. I beg for an opportunity. No copy has been given, Lord.
How are you? You are a party to the contempt.
No, my Lord, but it has been tagged with, my Lord. Kindly
Please, a copy of the contempt petition.
Next step, Lordship.
Learned advocate appearing for the appellant in MAT 1578 of 2024 prays for a copy of the contempt petition be served on him. Stop. Let a copy of the contempt petition be served on him. Stop. Next. The contemptor is not represented, nor has any accommodation been prayed for. Stop. Same September 3rd. List this matter on September 3rd, 2026 for further consideration. The petitioner is directed to serve a copy of this order on the alleged contemptor to enable him to appear on the returnable date. Yes.
Lordship, I file the exception. Lordship, I will file the exception against.
Something on record.
Don't have it on record.
This is something you've handed up, no? Let them come, let them file an affidavit of compliance.
একটু নামটা লিখে দিয়ে জানা হ্যাঁ কারণ আপনার নামের স্পেলিংটা যদি ভুল হয় কোনো কারণে
Original said content matters item number 1.
If I take back the order, compliance order.
I've given it back. ওই অর্ডারটা ওই এটা দিয়ে দিন শীটটা ফেরত দিয়ে দিন ওনাকে শীটটা
This is
reach.
This is my application for contempt. Now, my lord, this application arises out of an order passed by the Honorable Division Bench on 7th October 2024. Lord, this is a case, if your lordship will find at volume 2, annexure E, page 150. Now, my lord, this is a 150, volume 2.
ये वॉल्यूम 2 देना गोपाल इसी में yes
Now, my lord, this is a case where, my lord, an unauthorized construction was directed to be demolished. Now, my lord, there was the landladies rather. My lord, there were poor landladies, my lord, who were, my lord, in the Honorable Single Bench directed the developer to pay for the alternative accommodation an amount of rupees 50 lakhs. Now, my lord, an appeal was carried from that order before the Honorable Division Bench, and that order was modified to rupees 25 lakhs. Now, my lord, till date, my lord, neither an alternative accommodation has been provided, nor, my lord, the amount as directed by the Honorable Division Bench has been paid to the, my lord, those elderly ladies who have lost their house, their shelter. Your lordship will find the order at,
appearing for respondent number 1314
my lord. Initially, beloved, I also point out before your lordship, after your lordships had directed that payment, modified the order, the contempt application was going on before the Honorable Single Bench. Now, my lord, since your lordship has passed the order modifying, my lord, the initial amount to be paid to those landladies, now, my lord, the Honorable Single Bench has been pleased to pass an order on 18th November 2025. My lord, the Honorable Single Bench has been pleased to direct that the Honorable Single Bench does not wish to proceed with the application for contempt in view of the order passed by the Honorable Division Bench, granting liberty to the applicant to approach the Honorable Division Bench.
page
Your Lordship will find, Lord, at page 177 of my volume 2. Now, in keeping with this order, Lord, I am before your Lordships.
The contempt before the
Honorable single bench, Lord,
was filed prior to disposal of the appeal.
disposal of the appeal that was going on. Now, my lord,
The appeal was disposed of on October 7,
7,
2024.
yes, my lord.
Who sat tight over the matter.
No, the contempt was going on before the honorable single bench.
After the appeal court's order, how can the contempt before the single bench go on?
No, the honorable single bench was proceeding with the contempt, my lord. And on 18th of November, my lord, this order was passed that granting liberty to the petitioners to prefer appeal before your lordships. Several orders have been passed thereafter, my lord, after the
The petitioner alleges contempt of the directions contained in the order of October 7, 2024. So, by the said order, the Honorable Division Bench had had modified the order of the learned single judge, thereby directing the appellant stroke respondent number 11 therein to deposit a sum of rupees 25 lakhs with the Registrar General, High Court, Calcutta, for the alternative accommodation to the respondents 13 and 14 by November 10, 2024. Stop. Next. The Honorable Single Judge, by the order dated November 18, 2025, has disposed of the contempt application filed before the bench in view of the order of the division bench. Stop. Hence, the present contempt petition. Stop. Next. Let a copy of the contempt petition be served on the alleged contemners. Contemner or contemners?
contemner.
The alleged contemner. Stop. List this matter on September 3rd, 2026 for further consideration.
I'm grateful to you, lordship.